Senate Judiciary is now in session. The Honorable Sharon Carson is before us to bring forth an amendment on HB 1220. Welcome, Senator Carson.
Thank you very much, Mr. Chairman. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for the committee's consideration this afternoon an amendment to House Bill 1220. We had already heard 1220, but the Secretary of State's office approached me, and they said that there was an issue with a bill that we had concurred with, which is Senate Bill 255, dealing with privacy. And in that bill, they were given certain responsibilities, and they need legislation in order to fulfill those responsibilities. So the amendment that you have here is their recommendation. There are members from the Secretary of State's office to answer any questions and to walk you through the amendment. So thank you very much for your time and consideration this afternoon.
Thank you for your testimony, Senator Carson. Does anyone else wish to testify on the amendment?
The chair will call the Deputy Secretary of State, Erin Hennessy. And you also have Bud Fitch and Tom Connolly signed up, the three of you together? Okay, great. I'll be right back. Go ahead. Go ahead.
Thank you, Mr. Chair, members of the committee. Nice to see everyone. SB 255, as Senator Carson mentioned, passed the House, or it was originally Senate bill, and when it went over to the House earlier this year, they made a change last minute with an amendment and added our office to do some things that we don't normally do. And so this amendment, and unfortunately we didn't have time to make a change before SB 255 was signed into law. So I appreciate the committee's the opportunity the committee has made to bring forth this non-germane amendment to the other bill. So what this does, takes out some of the responsibilities that the House's amended version of 255 did, which required the Secretaries of State's office to do some things that we don't normally do, which is one, go through the rulemaking process. Our office doesn't have staff to do rulemaking. We've not done rulemaking before. And our priority would be to get legislation to change what the law said, to actually put into law what other states have done for their privacy legislation. Several states already have privacy laws in place. For example, New Jersey, Connecticut, Colorado, and some of the language that is proposed in this amendment removes our responsibility to make certain determinations and just puts what the what the law regarding the privacy would be. Specifically, it defines the term secure and reliable means, and it takes out our responsibility to come up with a definition for that. It also, on the second page of the amendment, adds some information in requiring the controller to add a phone number or a U.S. mailing address so the consumer may contact them. And also requires the privacy notice to be dated to determine when the privacy notice was last updated by the controller. I'm happy to go into more details. I've got a great team here that can answer any questions. We do understand that there is a few changes that are going to be proposed behind us. We don't have any objections to the changes to those amendments. But if you have any questions on where we came up with this language here, we're happy to answer those.
Thank you very much for your testimony. Mr. Fitch?
I have nothing further unless you have questions.
Mr. Connolly, do you have anything you wish to add?
Thank you.
Okay, great. Are there any questions from the committee? Seeing none, thank you both very much. The chair will call Rick Fabrizio. Good afternoon, Mr. Fabrizio. and I owe you an apology. You had sent me an email, you wanted to talk to me, but this, quite frankly, is our crazy season right now because we have so many bills. So please, I hope you can accept my apology that I wasn't able to get back to you.
I will apologize as well, as I think I indicated that we weren't going to speak today, but after further discussion, we decided it'd be in the best interest if we did. Thank you today for letting me speak. I'm Rick Fabrizio, Director of Communications and Public Policy for the Business and Industry Association. We're New Hampshire statewide Chamber of Commerce and leading nonpartisan business advocate. I thank you again for the committee's work in advancing Senate Bill 255 on its way to becoming law. It provides proof that it's possible to provide consumers with strong control over their personal data and businesses with a framework that allows innovation and flexibility. The law is modeled after privacy laws passed in 15 other states. However, in departure from most of those states, New Hampshire's law contains duties for the Secretary of State, which require the office to play a regulatory role in how certain businesses interact with consumers. None of the other 15 states require their Secretary of State to serve in this role, and the vast majority of states don't have any state official serving in that capacity. As such, BIA supports this amendment's objective of clarifying the duties of businesses and the role of the Secretary of State. However, BIA believes the secure and reliable means definition in Section 2 and the notice provision in Section 5 require revision to achieve the amendment's goals while allowing businesses the flexibility to protect consumer data. Specific concerns include, starting with Section 2, the definition of secure and reliable means should be amended to reflect the reality of data protection and to keep the definition relevant as best new practices are developed and brought forward. The definition currently requires that technologies and protocols used to achieve the secure and reliable standard must ensure certain outcomes. However, it's impossible to guarantee an outcome in every instance in the context of data security. Qualifying reliable means as designed to reasonably ensure would continue to articulate a clear standard, but not create unobtainable goals. Similarly, the definition currently contains an apparent conflict in these standards by requiring the means utilized must ensure while referencing a significant risk standard. BI believes this too can be fixed with a minor change. For Section 5, it would be ideal if it could provide further clarity on how controllers must provide notice to consumers. Such notice is essential in consumer data privacy laws, which function best when consumers understand business practices and can make informed decisions. Section 5 lacks the flexibility businesses need to communicate effectively with consumers. Many connected devices today do not have a screen suitable for consumer viewing of privacy notices. This section should be amended to make it clear that online or mobile application notices are appropriate in the absence of screen notification. Again, thank you for consideration of these issues. BI looks forward to working with the committee, the Secretary of State, and other stakeholders to improve this amendment, and I'm happy to take any questions if you have them.
Thank you very much, Mr. Fabrizio. Are there any questions from the committee?
Okay.
Seeing none, thank you
Thank you
very
very
much.
much.
Okay, are there any other members of the public that would like to speak to amendment number 2024-1486S? I believe you had, oh yes, you did. Please come forward.
Madam Chair,
Yes.
may I ask a question of you?
Sure.
For clarification, I just want to clarify that the amendment you've presented in no way touches the bill as we first heard it, that is
Correct.
completely retained.
Correct. I was
Thank
looking
you.
for something that was germane, and this was about as close as I could get.
Great, thank you very much.
Thank you. And I know Representative Ming is here, so I hope you're okay with this. It should be okay. We'll make it work. Okay, thank you. Please, Ms. Weston.
Thank you so much. For the record, my name is Maura Weston. I am here today on behalf of the New England Connectivity and Telecommunications Association, known as NECTA. I appreciate the opportunity to be here, and we signed up as neutral, but in general, we support the construct of this amendment. And as indicated by the BIA, we think that a couple of small tweaks to the language would greatly improve it. And we hope to work with the stakeholders in that process. Again, as pointed out by the BIA, we would like to qualify the definition of secure and reliable. As proposed, it uses the term ensure, which may not be workable in today's dynamic online environment. While it's a laudable goal, it may be impossible to ensure such functionality. So again, we're sure that with limited edits, language would reflect an appropriate standard for data protection. Further, the definition is prescriptive relative to what protocols should be used to protect data. And while these are all great protocols, as of now in 2024, technology will evolve, and we would support revisions such that the language would allow for flexibility relative to future security standards. Additionally, Section 5 of the amendment makes changes to the notice requirements in the law. We agree that such notice should be reasonably accessible, clear, and meaningful. But again, as pointed out by the BIA, it is not the case that every device has a screen. And so many devices collect and use consumer data. And with minor edits, the language could be more flexible to allow a controller to provide notices through other methods, for example, online or via a mobile application. Thank you for the opportunity to be before you, and we look forward to working with the stakeholders on further amendments.
Okay, thank you very much for your testimony.
Thank
Ms.
you very
Weston.
much.
Are there any questions for Ms. Weston? Okay, seeing none,
Thank
thank you
you.
very much. Okay, are there any other members of the public that would like to speak to amendment number 2024-1486S? Representative Ming, if you'd like to come forward, make sure to identify yourself for the
Absolutely.
record.
For the record, Representative Ben Ming for the town of Hollis. Good to see you, Madam Chair. I'll just say it for the record, no objections to this non-germane amendment to HB 1220. And as long as the House passed bill is untouched, I have no other questions. So.
Okay, thank you very
Thank you.
much, Representative. Okay, are there any other people, any other members of the public who would like to speak to amendment number 2024-1486S? Okay, seeing none, we'll close the public hearing. Thank you. Yes. No. Okay. Okay, yes. Going to go ahead and open the public hearing on House Bill 306 and call the prime sponsor, Representative Nutter Upham. You are, I only called one person?
Oh, I'm sorry. She's Representative Raymond, and she did the work on the amendment. So I was
Okay,
going to.
I'd like to call you separately, if
Okay.
that's okay. No,
Sure.
you're Representative Nutter Upham. Okay, we'll hear from you first. You'll introduce the bill, and then I will call her after you.
Thank you.
Okay, thank you.
So, hello, I'm Representative Fran Nutter Upham, Hillsborough 8, Ward 6, Nashua. I've served on Health and Human Services for 3 terms, 6 years now. I'm a licensed clinical mental health counselor for over 25 years. I've worked in pretty much every avenue of mental health, inpatient, psychiatric, outreach, community, and so forth. I brought this bill, 306, forward to protect children from being subjected to unproven, harmful, and supposedly therapeutic techniques offered by non-licensed people. This bill has been expertly amended by Representative Raymond, who serves on a Child and Family Law Committee. The committee passed the amendment and unanimously for this bill. So she has a more succinct explanation of what this bill is all about, and I would like to end my testimony now and have her come up.
Thank you.
Thank you.
Are there any questions? Senator Gannon has a quick question.
Just a new topic for me.
Okay.
So is this more like religious type of bringing people together? Or
No.
what? No. Okay.
No.
That you were trying to. Okay.
Okay, it's a good
Look forward to
question.
hearing more about it.
Okay, thank you.
Okay, thank you. The chair will call Representative Raymond.
Thank you, Ms. Chairwoman, and I apologize for the confusion earlier.
That's okay.
I'm Heather Raymond. I represent Hillsborough District 5, Nashua. Before becoming a representative, I was a forensic interviewer in New York State, which means I interviewed children who were the victims of severe physical or sexual abuse along with the New York State Police. I've been a child protective investigator in New York and an assessment worker here for DCYF in New Hampshire, and I've worked for CASA. I'm also on the Board of Education in Nashua because I'd like to have lots of hobbies. I'm here to talk about HB 306. As amended by the House Child and Family Law Committee, HB 306 protects both parents and children involved in custody cases by requiring that judges give due consideration towards selecting a counselor who is a participant in the party's health insurance carriers when ordering counseling as part of a parenting plan. Parents have testified to the Special Committee on Family Court and shared with the House Child and Family Law Committee members that it can be cost prohibitive when judges order therapy services that are not covered by either party's health insurance plan. Divorce is already costly, and many New Hampshire families are struggling to make ends meet. Parents want their children to receive support in these difficult circumstances, but they want the courts to make due consideration of how parents can afford to pay for it. HB 306 does not prohibit judges from ordering services that aren't covered by insurance, but it does require them to start with services that are covered or those that are agreed to by both of the parties. Parents also want court-ordered therapies to be helpful to their children and delivered by counselors they can trust who use safe and effective techniques for repairing damaged family relationships. Over the past decade, there has been a rise in unlicensed persons or agencies who use harmful practices that are designed to break children's spirits under the unscientific theory that it will encourage rebuilding and attachment to one of these parents. While these programs are frequently called reunification therapy, they often fail to meet the ethical or evidentiary standards to be considered therapy or counseling. So-called reunification therapy is universally rejected by licensed mental health practitioners and health insurance agencies. These programs are almost always aimed at adolescents and teenagers and require harmful practices as a condition of participation. They frequently employ no contact orders with one parent or other extended family members without evidence of abuse, transfer of custody from one parent to the other over the objection of the child, the use of threat or force against the child to compel compliance, undue coercion, and verbal or physical abuse or isolation from the child's community or other supportive services. Many of these programs use a boot camp style program to isolate adolescents and break their spirits. Sometimes they employ people to pick up the child and transport them to the facilities without notice and against the will of the child. After reaching adulthood, young people who have been in the programs report that the experience was traumatic and scary. Many thought they were being kidnapped and report feeling betrayed once they realized their parent and the court system are responsible. States like Colorado and California have passed legislation to outlaw these programs after children in their states have died in the programs. Further, there's no evidence that these programs achieve their stated goal of repairing the child's relationship with the parent who felt alienated. In fact, the vast majority of young adults cut off contact with the parent with whom they had been reunified as soon as they were legally old enough to do so. These programs cause trauma and disruption, not healing. Reunification programs like this do exist in New Hampshire, and there is a judge in New Hampshire who orders the use of reunification therapy. This is harmful to children and not good for families. HB 306 prohibits judges from ordering any family reunification programs or services for children that use specific techniques like youth transporters, threats of force, physical or verbal abuse, isolation, or circumstances that place the safety of the child at risk. Parents who feel that they've been alienated from their children deserve to have therapeutic options that are evidence-based and work to repair and rebuild damaged relationships. They should be able to trust that the family court system is not going to order their children to participate in programs that could cause further trauma and harm. The House Child and Family Law Committee unanimously agreed that HB 306 is in the best interest of children because it provides important protections to families as they navigate divorce and custody. I hope that this committee will do the same.
Thank you very much for your testimony. Are there any questions? Senator Chandler?
Thank you, Madam Chair. I have a question about, two questions, if that's all right. The first is about private youth transporters and private transportation agents. Is there any definition that exists or any training that is given to folks who are under that title? And I'll ask my second question as well. The phrase undue coercion, is that a phrase that's generally used, or would coercion be sufficient?
So the phrase, I'm going to answer them backwards. The phrase undue coercion actually came from both the Colorado and the California statutes use that phrase. So it seems like that seems to be the phrase du jour at the moment. I think that just using coercion may give the impression that you can't talk a child into something. And I mean, certainly we talk to our kids and we try to commit, which these are typically aimed at teenagers. Teenagers can frequently just refuse on principle because that's part of the natural adolescent development. So I think it's okay to say, listen, I want you to do therapy with dad to try and repair the relationship. And if you do that, we will, have some sort of reward if you give it a good, honest try. But undue coercion, I think, is if you don't do this, you will have a punishment that is abusive or harmful. Does that make sense? As far as the transporters, I'm not aware of what kind of training they have.
Thank you.
Great. Senator Abbas?
Thank you, Madam Chair, and thank you for taking my question. If you look at lines 5 and 6, it discusses, at least the way I read that, 4 to 6. It looks like it leaves it to the parties to perhaps recommend which counsel they want to use as opposed to the court perhaps selecting it.
Right.
The question I have is, or this potential concern is, there's limited counselors and therapists that actually provide this type of services. So quite often I've experienced that a parent will object simply knowing it's a limited market, and therefore you may not be able to find someone to actually serve as the counselor, because sometimes there's also a distance restriction as well.
And I think that is an additional problem. One of the reasons why on line 5 it says is recommended, it says the court shall give due consideration to selecting a counselor. The court isn't prohibited from ordering a counselor that's outside of the insurance plan, nor are they prohibited from ordering a counselor that both parents don't agree to. But we're asking that the court start at that point. And certainly there are circumstances and there are families who might say, listen, I would prefer pastoral counseling. That's what works for our family, and they're not covered by our health insurance. But if both parents agree that that's what's best for the family, then there's no reason why the judge couldn't order that. Now, if one parent says, I want my religious counselor, and the other says, I want my religious counselor, and they can't come to an agreement, then the court has to make some sort of determination.
Follow up?
Maybe this has happened before. I would be shocked to hear that a court, if two parents agreed on a therapist, that the court would then reject that joint agreement.
No, I haven't seen that myself. If both parents are agreeing, we want the court to say, okay, let's do it that way. Because that's the whole point, right, of when you're going through these parenting plans, is to get the parents to mediate and come to an agreement without the judge having to say, no, you have to do it this way.
Thank you.
Okay, are there any further questions? Thank you, Representative. I think you bring up a number of very good points. I've been chair of this committee for quite a while, and I remember parents coming and saying, the judge was saying, hey, you got to go for counseling, here's the counselor. And they're like, no, we don't want that person, they're not in our insurance, and we're gonna have to pay out of pocket, I can't afford it. And they don't take the child, and then they're being held in contempt of court because they didn't produce the child for counseling. I think this is a very good change, and it recognizes the fact that sometimes people have to go through their provider, and it gives everybody a little flexibility, and I appreciate that. The other question I had was Representative Nutter Upham had said that this is only going to apply to non-licensed facilities. Do we have any licensed facilities here in New Hampshire that do this?
Reunification therapy? No, licensed counselors won't touch it. There's some confusion because of the term reunification, right? So if you read, for example, the child protective statutes, and there's an obligation for courts to reunify families, right? You have to work towards reunification. Mm-hmm. So the people who offer this, I'm using my air quotes here, the people who offer this type of reunification therapy have co-opted that term, and they're using it for something completely different. So we do have a number of licensed therapists who offer family counseling. We have non-licensed people who do pastoral counseling, but we don't have any insurance companies that will pay for these types of programs because they are harmful.
Okay, thank you. Are there any additional questions? Seeing none, thank you very much for your testimony.
Thank you.
Okay, the chair will call Sarah Tollefson. Good afternoon, Ms. Tollefson.
Good afternoon. My name is Sarah Tollefson, and professionally, I'm a social justice advocate, but today I am here as a caring adult to speak up for children across the country who are traumatically affected by reunification therapy. I am here in support of HB 306, an act relative to prohibiting reunification therapy. I assume many of you are, like I was a couple years ago, completely unaware about an industry in our country where children are taken from their homes or courtrooms while they are crying, screaming, and begging not to go. They are removed from a parent's home they do not want to leave, a safe parent, and brought to a faraway location to be with another parent, oftentimes an abusive parent, to force the child and parent into reunification. They are often removed by transporters, complete strangers who are physically tearing children away as they literally fight for their survival. This singular event is so incredibly damaging to a child, only to be followed up with days, months, and yes, years sometimes, away from their safe parent and in the care of their non-preferred and often abusive parent. As a parent, my heart is shattered for those kids and for their safe parent. These reunification therapy camps are unregulated and ordered from family court at the recommendation of various types of professionals, all whom financially benefit from the existence of this industry. In fact, I challenge you to find a professional who does not benefit from the reunification industry who supports it. I heard of a very recent case in Pennsylvania where a reunification therapist, air quotes, a man who had his doctorate in sociology and no practicing license of any kind, yet was practicing as a sex therapist, met with 2 children for 1 hour, deemed them in need of reunification with a non-preferred parent, and the safe parent was threatened with jail time if they did not comply with handing the children over. I listened on video to the children cry, scream, and beg in court as custody was stripped from their safe parent. This is just one story. There are so many others across the country, and it seems so inhumane, it's hard to digest as really happening now. Outside the institution of family court, we want children to speak up when they are being harmed, and we as a society invest greatly in protecting our children. We know that when children have adverse childhood experiences, that trauma can have effects for their lifetime to come. We all can agree. We want children to be and feel safe and well. But within the institution of family court, we are often more preoccupied with the notion that parents have rights to the presence of their children, even when a parent has been proven to be abusive. Children are just smaller humans, and just as adults react to people who treat us poorly, so do children. And they cannot be forced into a situation of reunification in a short period of time. That's not really reunification, it's coercion. I would challenge you to find a young adult who attended reunification therapy who has a loving relationship with the parent they were reunited with. There is a concept and center devoted to a cause called institutional courage. From their website, we depend on institutions. Institutions are the building block of a civil society. They are crucial to our well-being. We depend on our government, police, and hospitals to protect our lives. We love institutions that give our lives meaning, such as our schools and places of worship. Sometimes institutions really help us. All too often, institutions betray us. Sadly, institutions often make our lives worse, not better. They don't protect us from harm. They are indifferent when we suffer. They focus first on profits and self-protection. The most vulnerable people are the hardest hit. We are in a terrible bind. We depend on institutions that betray us. Institutional courage is an institution's commitment to seek the truth and engage in moral action, despite unpleasantness, risk, and short-term cost. It is a pledge to protect and care for those who depend on the institution. When family court orders reunification therapy, it is institutional betrayal. When police, other caring adults, or governmental bodies stand by and let it occur, it is institutional betrayal to those children. They are counting on all of us to keep them safe. Let's not betray those children. Thank you.
Thank you very much for your testimony. Are there any questions? Senator Abbas?
Thank you, Madam Chair, and thank you for taking my question. With this, are you opposed to any form of unification therapy? I understand like the camps and these programs where the child's taken away for an extended period of time. My understanding of unification therapy is something that if you did do it, it would be done very slowly and kind of in increments, not as drastic as you described. So
Absolutely.
Is there any form of reunification therapy that you would support?
Like family therapy with licensed therapists.
Follow-up?
And this would still permit for that, this wouldn't forbid that, would it?
I believe it does, yes.
Thank you.
Okay, are there any further questions? Seeing none,
Thank you.
thank you very much for your testimony. Are there any other members of the public who would like to speak to House Bill 306? Please come forward and identify yourself for the record.
My name is Dana Albrecht, Nashua, New Hampshire. I am not a therapist, nor do I have experience in that realm. I will defer to the opinions of everybody you've heard before concerning what is and isn't appropriate therapy. With that said, I have a couple concerns with just specific language here, and I'd like to address Senator Abbas. Did I pronounce that correctly?
You got it?
Yes. A judge in my case held a 3-hour hearing sua sponte to order over the objection of both parties that New Hampshire no longer had jurisdiction. And so my specific concern here is just with line 11B on jurisdiction. I just want to make sure we're not preventing, I live in Nashua. My oldest son lives with me in Nashua. My younger daughter lives separately in New Hampshire. Her brother lives in Michigan. They've lived for California a while. So I just want to make sure on this overnight out-of-state or multi-day stay that we're not preventing people who live in Nashua from booking an appointment in Boston or hopping on telehealth, or that we basically can't go hopping around state lines in a legitimate way for what good quality family licensed systems therapy think might be appropriate. And just want to make sure we're not preventing people from doing that. Thank you.
Thank you very much for your testimony. Are there any questions for Mr. Albrecht? Seeing none, thank you very much.
Thank you.
Okay, last call. Are there any other members of the public? Ma'am, please come forward, identify yourself for the record.
Hi, my name's Paula Worma. I'm a practicing family law attorney in New Hampshire. I think the bill overall is excellent and good points have been made. I'm a little concerned about the language that says the court shall give due consideration. I think that gives judges a lot more room to ignore the rest of the wording of the bill and to refuse to follow it. Most reunification counselors, it's a small group of counselors in New Hampshire. It's probably only 24 out of 4,000 licensed mental health professionals, rely on court appointments for their living. And I can see judges ignoring the part that says they have to use the parties participating health insurance. And the other thing that I'm concerned about is I think reunification therapy needs to be banned entirely as reunification therapy. I'm not against family therapy, but court-ordered family therapy winds up being a problem. Judges tend to use it for the purposes of reunification and really little else. I spent several months in 2022 and early 2023 studying the complex case docket, which is littered with instances of child abuse and domestic violence. And these are the sorts of cases that the judges are ordering reunification therapy on. I'll quickly tell you about the worst case I found. A case where 2 young girls testified against their father in a criminal trial in Massachusetts regarding sexual abuse. In a bench trial, the man was found not guilty. Remember, there's a higher standard of proof. And the case eventually went back to court, and the Rockingham County judge ordered the children into reunification therapy. One child subsequently spent several months in a mental health institution, which I couldn't completely tell, but I think was a result of finding out that the case plan was for reunification. And the judge, in a court order, exhibited disappointment that reunification was proceeding so slowly. It wasn't proceeding slowly. The child was a mess in a mental institution because it was ordered at all. I just ask you, because of that case, which was so stark and really horrible to read, maybe you should consider stronger wording than the court shall give due consideration. Thank you.
Thank you very much for your testimony. Are there any questions? Senator Abbas.
Thank you, Madam Chair. And thank you for taking my question. I asked this to the previous member of the public who testified, but with this, I'm wondering if this language would ban any form of reunification therapy, or would it leave open perhaps, reunification therapy with a licensed counselor or a licensed social worker?
I agree with the last speaker. I don't think it bans family therapy, but I think it needs to be with licensed professionals who are following ethical guidelines, which is family therapy. It's not reunification therapy.
May I ask a follow-up?
Follow-up.
So I'm looking at lines 6, and it says in bold, the court shall not order family reunification treatments, and it goes to say programs or services, and it kind of lists a bunch of, so I was reading that the treatments might include perhaps some type of family therapy that would involve reunification.
Okay, but I'm reading a little further that says, or that as a condition of enrollment or participation require any of the following, and A, B, C, and D talk about ripping the parent away from their safe parent and handing them to their abuser. And I I absolutely know of cases where this has happened.
Thank you.
Are there any further questions? Okay, seeing none, thank you very much for your testimony.
Thank you.
Okay, last opportunity for anyone who would like to speak on House Bill 306. Okay, seeing none, we'll close the public hearing. Who is the- Nelson? Okay. Going to open up the public hearing on House Bill 475 and call the prime sponsor, Representative Post. Good afternoon, Representative.
My name is Lisa Post, and I represent and New Boston. Thank you. Madam Chair, I thank you for taking this time today to listen to our testimony. I appreciate the opportunity that we have to help families. And HB 475 allows parties to present evidence and testimony to the courts. It's a simple bill that helps both parties know that when they submit evidence and testimony to the court, they can expect that their information will be reviewed and recorded. Unfortunately, it's my understanding that the judge is supposed to include facts and findings and conclusions of law, but that is not actually happening in the circuit family court. Basically, what this does is it allows both parties to present their evidence and testimony. And if one party objects, then the judge may allow that other party not to submit the evidence. And then what would happen is the judge would then record that he has denied it and put it in the record for the future. So as well as this is a simple bill, it's an important bill because it gives that person who was egreged and not allowed to submit that testimony, they have that knowledge that it's at least in the record. So I would urge you to support this simple bill that will help these folks who really feel egreged have the opportunity to have a record on record. So thank you very much.
Thank you very much for your testimony, Representative Post. Are there any questions from the committee? Seeing none, thank you very much.
Thank you. I appreciate your time today.
The chair will call Erin Cregan. Good afternoon, Ms. Cregan.
Good afternoon, Madam Chair, members of the committee. My name is Erin Cregan. I'm the General Counsel for the Judicial Branch. Thank you for the opportunity to speak on the bill. This is a bill that I believe was substantially modified so that it now requires that in the family division of the circuit court, there be a ruling in the record on any decision not to admit testimony or evidence of one party. I think that this does occur. For example, if one party says, this evidence is cumulative, you've already presented a lot of evidence, the judge will turn to the person offering the evidence, say, does this add anything new? There'll be argument, and the judge will say, okay, this is cumulative. We're not going to consider this additional evidence. So I believe that's typically the process as you might visualize courtroom process right now. What I think has been potentially a little confusing in some of the conversations around the version of the bill that exists now is whether in the record requires a written ruling. In the course of a proceeding, particularly an hours or days long proceeding, written rulings on every decision of evidence, which might be dozens or even hundreds in a proceeding, would be prohibitively time consuming. So although I certainly agree that judges should be explaining their rulings in the record, on the record, that the parties can understand, and I believe that judges make every effort to do that right now, I would suggest that it may be worth including in the language that an oral explanation is sufficient, because some of the conversation in the legislative record might suggest that it would need to be a written ruling, and that is a large amount of judicial time that would be committed to that if that were to become the law.
Okay, thank you. Are there any questions? Ms. Cregan, I'm looking at the proposed bill here, and it's beginning on line 3, and it just says, if the court admits evidence or testimony over the objection of one of the parties, or the court chooses not to admit evidence or testimony offered by one of the parties, the court shall note in the record. It doesn't say anything written, so would you prefer either written or oral? So that way something will get in there rather than just kind of leave it, well, we're not too sure what it should be. So just be very specific. It can be a written note or an oral notation in the record.
Yes, ma'am. I agree with you. As I read it, it seems as though it could subsume any form of ruling, but I know there was a substantial amount of conversation that's in the legislative record on the House side that some were expecting that it would be a written ruling, and I would not want a person to be confused and believe that that legislative record is indicative of the meaning of these words.
Okay. Okay, thank you.
Thank you, ma'am.
Are there any further questions? Seeing none, thank you. Okay, the chair will call Katrina Heinrich. Good afternoon.
So on this bill, I'm kind of neutral on it at this point. I would summarize from experience and from observing other cases that the family court has a big reputation of functioning on all hearsay and artificially manufacturing some of their orders. With that said, the intent of the bill is to establish the right to submit evidence and testimony. And I thought we already had that right under the Constitution. When you're going to take away somebody's liberties or rights, there has to be some type of procedure in a criminal court to do that where there is evidence. So while I understand the application is for family court, I think that we have to address some underlying issues first. Some of those that I made note of was like our New Hampshire Rule 1.2 waiver of rules, New Hampshire Rule 2.2 application of New Hampshire Rules of Evidence. You got to look at the scope and applicability of that. I feel like the bill has some vulnerabilities when it comes to actually having enforceability and accountability of the contractors who are going to be doing this. I also look at 490D, where there's requirements that judges are supposed to be doing or marital masters. I also look at 490D3. The first one was D9. This is D3, looking at, transparency and consent and how that comes to be when you are actually being brought into the court. And as a citizen, we all trust in that concept. And then when you get in there, things are completely different than what you actually believed. So in summary, I feel like that it's to establish the right to submit evidence, but I feel like in family court, the intent aligns more with fulfilling the requirements of Title IV. And in that, they have to establish a primary parent and an absent parent. And at that point, they can fulfill as many requirements as possible from Title IV, which really does help bring in finances to the state, not to mention the incentives that it is for the contractors. Contractors having immunity, of course. The family court bills, they've had like little impact, I've noticed, on due process and enforceability. Like I see them going in, but I don't see a lot of change to what's happening in the family court. And I feel like there's a wave of people working against trying to fix the family court itself, what the problems actually are. And I bring it right back to the incentives of Title IV. And the only solution I've seen, while this is a good, really good effort, and I think it was phenomenally began, when they removed the section that said this right shall not be limited by the presiding judge. That was a big element of this bill, trying to enforce that. So I feel like the solution really is to close down the family court. And then let's make a new family court that actually serves the citizens. Thank you.
Thank you very much for your testimony. Are there any questions for this witness? Ma'am, I was flipping through, I finally got a copy of the original bill. And could you repeat the section that was removed?
Yes, the section, and I don't think I paraphrased it. I think it says, the right shall not be limited by the presiding judge, magistrate, or marital master, or by the New Hampshire rules of evidence, or the rules of the circuit court family division, which brings us back to those rules I kind of pointed out. 1.2, the scopability, 2.2, looking at the rules of evidence. So it was trying to help take care of that problem. And now it's been amended out.
Okay. Senator Abbas has a question.
Thank you, Madam Chair. So quite often when a party objects, they don't always even say why they're objecting, and then the judge can say either sustained or overruled. You know, that's just kind of how it is. But sometimes, how is the court supposed to make it the written determination unless the person objecting states what they're objecting to? My understanding is if someone doesn't agree with the decision the court made, whether it's the sustain or overrule, they can ask the judge to make a written determination of the reasons behind that decision already. So they can do that already. They just have to request it.
Mm-hmm.
And I guess having to do that every single time may be quite burdensome.
Oh, no, and I understood that when they first initially talked about this was the burden on the court itself. Sadly, my concern would be more about the burden on the citizens and the results of what happens in the court. My family and I being one of those victims. When I understood what was actually going on, it was far too late. And when I see how there was literally zero evidence for us to even be in court post-divorce, I have to come back to my original statement, which is it's all hearsay and artificially manufactured. And we know that the court is ran by contractors, and we know they financially benefit, as does the state.
Follow up?
Thank you.
Oh, okay, thank you. Ms. Heinrich, do you know
yes.
why that language was removed?
I have no idea.
You have no idea?
I read it last night and I went, oh, it's amended. So, yeah.
Okay.
Yeah.
All right, thank you.
Mm-hmm.
Okay, next we're gonna call Dana Albrecht. Good afternoon again, Mr. Albrecht.
Good afternoon. Again, for the record, Dana Albrecht, Nashua, New Hampshire. I do think this bill is a good idea. I would suggest that it might be improved at a minimum by the addition of 5 words at the end of section 5, and that would be, well, in context, the court shall note in the record the reason for its decision and the evidentiary standard applied. And I think that gets back to the prior testimony you heard on rules of evidence. It also addresses a lot of issues that were raised in hearings before the special committee on the division of the family courts, where you have parties, there's a family law case, there may be a civil DV docket, there may be a criminal docket. So you have these different types of case types before a different judge and different evidentiary standards in all of those case types. In my own case, this would have really helped a lot. Family division hearing, November 15th, 2023. Judge Rouso said that no police reports were allowed into evidence at all, barring a criminal conviction. So, I'm in a hearing where I think the evidentiary standard is more likely than not. But if no police reports can come in for any reason unless there's a conviction, that implies that, something would have needed to happen beyond a reasonable doubt in a different docket. So that's kind of confusing. So again, just to bring it back, I think a requirement that we put in the record the evidentiary standard that was applied. Thank you.
Okay, thank you very much, Mr. Albrecht. Are there any questions? Seeing none, thank you.
Thank you.
The chair will call Paula Wernick.
Good afternoon.
Good afternoon again.
My name's Paula Werma. I'm a family law practitioner here in New Hampshire. This bill is a good start. I think I do like the old wording a little bit better than the new wording. I would like to call your attention to the fact that there are definitely judges. First of all, judges get to pick some of their own witnesses. If this were the case in the criminal bar, I think the matter would be in the U.S. Supreme Court inside of 18 months. The prosecution and the defense in the criminal bar pick the witnesses, and the judges have no business doing that. They don't really have any business doing that in the family court either, except the statutes permit them to do so. And I'll give you two for instances, actually three. The guardians ad litem. Not saying guardian ad litem is not a good idea, but the judge hand selecting them is tantamount to introducing bias. The same with anybody that the judge decides needs some sort of family evaluation to help him make a decision. It's the judicial bias that goes into that is very problematic. And it's a very small number of practitioners in New Hampshire compared to the number of licensed practitioners that are willing to do anything like that. They have a very close relationship with the judiciary and the guardians ad litems and other attorneys in the cases. So it's very important that parents be able to put on their own witnesses. I have seen judges deny expert witnesses. I've seen judges deny other fact-based witnesses. It's a huge problem, and it all goes to the 14th Amendment. So this bill is a start. I think we need to look at other reasons why the family court is as messed up as it is. I don't think the committee that they had last year came to some correct conclusions. I don't think they went nearly far enough looking at the due process issues.
Great, thank you very much for your testimony, Ms. Warner. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair. Do you think if we had a separate family court altogether, as opposed to not having it in part of the circuit court, would that be beneficial to some of the issues you raised?
My own research shows that the cases that tend to go to trial are the ones that three things are involved: domestic violence, child abuse, and the occasional case that has complicated financial issues where accountants are involved. Those generally didn't really interest me. I'm more interested in the domestic violence and child abuse side. I think juries are needed. And I know that I'm going way overboard what this bill calls for. But I don't think judges are the correct people to make decisions about whether or not domestic violence has occurred, whether or not women and children need to be protected from abusers, or the other way around, although the vast majority of abusers statistically are men.
Thank you.
Are there any further questions? Seeing none, thank you very much for your testimony. Are there any other members of the public who would like to speak to House Bill 475? Representative Raymond, please come forward. Make sure you identify yourself for the record.
Thank you, Madam Chair. Heather Raymond, representative for Hillsborough District 5 in Nashua. I am on the Child and Family Law Committee, and I just wanted to speak a little bit to some of the questions that came up. This bill was retained by our committee, and then we had a subcommittee to work on it, and then they came back with the amendment, which passed our committee unanimously. Some of the concerns that came up, both in testimony for the original bill and then in the subcommittee, was the original bill said that the right to submit testimony shall not be limited by the judge, the marital master, or the rules of evidence. So it became very clear when we had representatives from the judiciary come that someone could say, well, I think that reading the Declaration of Independence into my custody case is relevant. And they could, especially domestic violence and people who are seeking to control the other partner, could really use their ability to submit anything they want to drag out the proceeding, to cause their ex-partner to miss work, to create drama and problems. We also had circumstances where people wanted to submit, inappropriate photos. They wanted to submit all sorts of things with the express purpose of delaying or shaming or harassing their ex-partner. They didn't want to submit things that the judge was considering evidence. And so the judiciary said, listen, we need to be able to have some judicial discretion. Do we think that the rules of evidence should apply? Yes. And in family court, judges need to also accept things that maybe wouldn't be accepted in criminal court. So for example, a judge in family court might consider reports of a child, because we're talking about best interests of children, not, beyond a reasonable doubt, evidence that would be required in a criminal case. So we wanted them to have some discretion, and I think that the original language would not have allowed that, would have really turned it into a circus.
Okay, thank you very much for your testimony. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair. I'm not sure if I heard you correctly. Are you telling me that right now, currently, in a family court proceeding, the court is not required to use the traditional rules of evidence?
So the family court has different standards than, say, criminal court, for example. And the judge has more discretion and leeway than they do in other courts.
Thank you.
Okay, any further questions? Seeing none, thank you again, Representative.
Thank you.
Again, are there any other members of the public that would like to speak to House Bill 475? Okay, seeing none, we'll close the public hearing. Oh, 306. That's the wrong one.
Yes.
We're going to go ahead and open the public hearing on House Bill 378 and call the prime sponsor, Representative Reed.
Thank you, Madam Chair.
Okay, hold on.
Although Representative Leon will be offering her own testimony separately to mine, I've requested, because of the personal nature of this, for her to sit with me for emotional support.
Okay. But Representative Leon, if you do decide you want to speak, you must stop and introduce yourself for the record. Thank you.
Thank you, Madam Chair, and thank you, honorable members. My name is Ellen Reed. I represent Rockinghamton, which is Newmarket and Newfields. This bill simply mandates that first responders inform their victims of their already existing, informs victims of sexual offenses of their already existing rights, including the right to a sexual assault state evidence kit. As amended out of the House, it gives a rulemaking procedure for coming up with a brochure or flyer that would enumerate those rights, again, that already exist, that then hospitals and doctors and other first responders could pass out to victims. So in 1988, for over 35 years, we have had the rights of victims to have an examination, a medical examination for forensic purposes, including a state sexual assault evidence kit, which is colloquially referred to as a rape kit. Also, in that year, a law was passed at the same time requiring that the Department of Justice send out guidance on these examinations and kits. So we have victims have a right to the kit. We have the AG's office is going to send all the hospitals how to deal with that kit and that evidence. But we never completed the loop, which is how do victims know that they have those rights? Because I think we, when in complete good intentions in 1988, just presumed that if we sent guidance to all the hospitals, obviously the doctors would read these rights, this legalese, how to deal with this, and they would know, and they would obviously tell their patients. This is what the AG's office sends out to all the hospitals. There is no emergency room doctor that is going to read this. Certainly not know it. Now, I'm not putting this in because of theory or whatever. I have my own personal story to tell as evidence of the system as it currently exists not working. When I told this story in the House last year, I was counseled by a fellow member who is also a therapist to use the third person, which I am grateful for that. I emailed the committee ahead of time and told them that I will be using the third person. I will say a woman in my district had this happen, but it is in fact me, so that I was being honest with the committee. I have another year separated from my incident, so I feel like I can own this and say it directly. For 2 years, I worked for Boston Duck Tours as a driver. You need like 9 licenses to drive an amphibious vehicle. And so as you can imagine, they have to pull captains from many states, including Maine, Rhode Island, New Hampshire. And so they offer a bunkhouse to sleep in for these drivers who work 11, 12-hour shifts and then might have to drive 2 hours home. So it's better to just stay above the garage. So I stayed in the bunkhouse regularly. I was pretty much the only female driver that did so. On one particular night, the bunkhouse was going to be full that evening. I should say it was the morning, and I was invited to a party that would happen in the bunkhouse, which has a lounge with a kitchen and everything. And I told them after I was done meeting up with my friend, I'd come and hang out with them at the party, which I did. I came and I poured myself a single drink. I had my guitar. I had my friend playing the guitar. I was singing. It was a very chill time. I drank all of my drink, and when I looked down a few minutes later, I had an identical drink, brand new, in front of me that I had not asked for, didn't see put in front of me. And one particular coworker, I looked over and kind of, did you do this? And he kind of looked sheepish, like, yeah. But I trusted him because I worked with him for 2 years. So I drank about a third of that beverage, and the next thing I know, I I don't know if you're familiar in that kind of sleepy state. If something's annoying you, my hand was being massaged. My head was on the table. My hand was being massaged, and I kept pulling my hand away. But he kept picking up and massaging it. So when I sat up, everyone else was gone from the room except for him. And I asked for everybody when he said they all went to bed, and I stood up. I said, I'm feeling nauseated, and I stood up to go to the bathroom to throw up. And he grabbed my arm, and he pulled me back into the lounge and didn't want to let me leave. I insisted that I had to throw up, so I went to the bathroom, and he let me, but he followed me into the single stall bathroom. And as I was vomiting into the sink, he groped me all over while I was throwing up. And then as I was, catching a breath, I kept saying, I want you out. I want you to leave. I want you to leave. And he's very specifically, while he reached down and grabbed my butt, he said, I don't care that you're vomiting. I'm just paying attention to your ass. At a certain point, I was able to stop throwing up. I pushed him out of the bathroom and locked the door. I continued throwing up so violently, in fact, and this has never happened to me before, that I lost my bladder completely. I cleaned up after myself. It was about 15 minutes, and I picked up my stuff and opened the door, and he was physically blocking the door with his hands in the door jamb like this. He is over 6 feet tall and at least 400 pounds. So I couldn't leave, and I told him, not knowing what else to do, I said, can you go get my phone in the lounge? And he went to go get my phone, and then I ran to my room. So the bunkhouse is one single room with a bunch of bunk beds, and then I, as the only female employee that stayed there, had essentially what is a walk-in closet in that room. So I ran to the room. He got to the door as soon as I got there, and he gave me the phone, and he asked to come in, and I closed the door in his face and locked it, and he continued to text me asking me to let him in. The next morning, I called my husband, obviously very upset and crying, who then came and picked me up to take me to the hospital to be tested for drugs. I am positive that I was drugged. I don't respond to one drink like that. And the way he was acting, the fact that he didn't offer a drink or say, here's a new drink, but he just slid it under me while I wasn't looking, and several other things. I'm positive that I was drugged. So I went to the hospital, and I told him everything that I just told you. And the doctor said that because I had escaped and was not penetrated, that I was not entitled to a sexual assault evidence kit, and that he wouldn't run it. And I have to tell you that even among my fellow legislators, all of whom are strong personalities, I am still known as a very assertive person. And that's probably putting it nicely. I can be a loudmouth. And I was fighting hard in that room for a test, but I still didn't get it. So I really don't know what hope there is for a person who is more mild-mannered than me, who isn't a legislator, who isn't in a position of authority or power, to learn their rights when no one is in the room to tell them what their rights are, and the doctor hasn't read all of this to know what their rights are. How do you know what you don't know? So after that, so I lost permanently my ability to have that particular piece of evidence against my assaulter. After that, I filed a complaint to the hospital, who then said that they stabilized me medically, so it was fine. Of course, I wasn't there for medical reasons. I was there for forensic reasons. After that, I decided that there was obviously a problem in the system, and that the hospital had told me that there was some sort of policy, they were very vague, that a policy that wouldn't let them run a kit on someone who wasn't penetrated. So I contacted the Office of Victim Assistance at the AG's office, or the Department of Justice, and they said, no, there's no such policy. In fact, here's the RSA that guarantees the right to a kit. And also, she said that there was, this is Linda Rule, said that there was an epidemic. I had 2 very long phone calls with her, epidemic of doctors who had no idea how to even process these kits or collect the evidence. They don't know what constitutes sexual assault. They don't know that they can submit just one element of the kit and not all. They're not mandated to submit all. So if a victim, for example, doesn't want a vaginal swab, she doesn't have to consent to it. She can still get the blood and urine, for example. They don't know that a kit can be collected confidentially. So knowing this, I asked the coalition to help me write a bill. I had 2 Zoom calls, which were not productive. They said that they are the ones that created the system, and so they thought the system was perfect the way it was and didn't want to change anything. Now, I admit that, this is very good, but this doesn't help victims, because what is the point of your right, of having rights, if no one lets you know that they exist? So, knowing that it wasn't just me, that this actually has been a problem with doctors not understanding this. And, in theory, a sane nurse should be called, but if the doctor doesn't know what sexual assault even is to begin with and thinks, hey, you weren't penetrated, so assault didn't happen, how are they supposed to ever call a sane nurse? No sane nurse was called for me. If one had been, perhaps they would have informed the doctor that I did have a right. The trauma of being assaulted that night and being afraid of what this guy was going to do to me, I had that for a long time, for months. I got rid of the clothes that I was wearing that night, just big, oversized, fluffy pajamas. And I didn't want to drink with friends for a very long time. And to this day, I just have a gut reaction when I see people who look like that guy. But I can tell you, more than the trauma for me, and I know that other people have it differently, more than the trauma around the actual assault itself, it has been so much worse being at best neglected and abandoned, and at worst actively betrayed by the people in the system who are supposed to be there to help you, the people who you are told to go to. The doctors, the lawyers, the police, the bosses, the advocacy organizations, all of whom are supposed to understand that you are traumatized, and they're there to help you and walk you through the system to do things to help get justice. And having their, as I said, at best, have them turn their backs on me and treat me with skepticism, like I'm lying, or I don't know what I'm talking about, or it's really not that serious, or I'm just a hysterical woman, or at worst, actively working against me and against other people like me, has been so traumatizing. Much worse than the original assault. And this is why people, men and women who've been assaulted, don't come forward. They know how they'll be treated. They know that this is the only crime where the victim in our culture is automatically blamed or look sideways at. Yeah, well, really? What were you wearing? Maybe you led him on. That's why people don't come forward, because of what we do to people who went through this. So maybe that's the culture we live in sometimes, or sometimes maybe these authorities and organizations are just trying to protect their business or prevent bad press. Or sometimes maybe there's a sense of territoriality, and they're worried that if they don't present themselves as the sole protector of victims, that they'll lose taxpayer funding. But in any case, it's why victims don't come forward. So like I said, I have lost irrevocably the chance to have evidence, not just against my attacker, but evidence for me to prove that I'm not lying, that I have no reason to lie, that I'm to be taken seriously. And so because I feel so alone, I am especially grateful for Representative Leon, who serves as the vice chair of the committee and was the chair of the subcommittee that worked on this bill. I've told her many times, even though we're on opposite sides of the aisle, that I feel like she came in with a cape, because she really championed and believed me and saw me and championed this when other people were not, just didn't care. I'm also grateful for the national organization RISE, who works specifically on victims' rights. The CEO of RISE was on Good Morning America today talking about this bill, in favor of this bill. So I am very grateful for the people who are there to to actually support victims. So as amended, I'll try to just briefly go over the actual bill as it exists. I did hand you all the existing RSAs. The first 2 pages are the right to an exam. The DOJ interprets the right to exam as inclusive of a sexual assault evidence kit, and that's made evident by the first page of the Attorney General's, I'll pass this out to the committee, Attorney General's guidance on the protocol of exam kits. The second page is the law saying that the DOJ will pass out to all the hospitals and first responders that protocol. And then the last 2 pages are the RSAs that the bill is amending, the sexual assault survivors' rights, and also the notification of those rights. So what the bill as it currently amended does is it makes it very clear that that includes a sexual assault evidence kit, not just a medical examination. And it in C, the new paragraph, it gives the rulemaking ability to create the document that will enumerate those rights. And it says inclusive but not limited to. And then in 4, it says that the healthcare providers, law enforcement officers, all those entities that already get the notification, the protocol from the AG's office, those entities will provide the sexual assault victim with this card. And so that's kind of just the overview. To get into details, like I said, Representative Leon worked extensively with repeated different points that especially the coalition had come up with. So we went through something like 4 different amendments. The version before you now passed the subcommittee unanimously, passed the committee unanimously, and passed the House floor on consent. So any more details, I would defer to Representative Leon's testimony whenever that's taken up. But I just want to express my gratitude one more time. And with that, I'll try to take questions.
Thank you very much for your testimony, Representative. Are there any questions? Senator Chandler?
I just have one question, and you said that it was one of the attorney generals who said there was an epidemic of doctors who do not know how to address rape victims.
I had 2 long conversations with Linda Rule, who is the victim assistant, and in those conversations verbally she told me that this was very long conversations, that this was a huge problem, and she was dismayed about it.
Thank you, and I'm so sorry for
Thank you.
what happened.
Are there any further questions? Seeing none, thank you very
Thank
much. Representative Leon, you just would like to sit and just make sure you identify yourself for the record.
Actually, Madam Chair, I have the speaker waiting on me. May I come back and testify as soon as I'm back in? I assume you have several people signed up to speak.
Yes, we do.
Would that be all right? I
Yep,
just wanted to
that's fine.
support Representative Reed.
Okay,
Be right back. Thank you.
That's fine. We're going to call Brittany Lane from RISE. I think it would be appropriate to have you speak to us now.
Thank you, Chairperson and committee members, for giving me the time to testify today. My name is Brittany Lane, and I'm here today as a representative from RISE, but I'm also here as a sexual assault survivor fighting for human rights for thousands of New Hampshire assault survivors. Most lawmakers and citizens are surprised when they find out that these basic rights for survivors are not always provided in a comprehensive way that is understandable to the average person. So when you go through this experience of an assault, you understand how broken the system can be. Although my assault did not occur in the state of New Hampshire, I believe that it's important that you know my story and why I'm here today. So I was sexually assaulted on November 2nd, 2019 by a coworker during a night out with friends. I repeated my story over and over that day, starting with local police and ending with staff from 2 different hospitals. Following giving my statement to the police, I went to my local hospital to have a rape kit done. I was immediately brought into a triage room and then transferred into a private room in the ER. I was seen by a doctor who then called for a nurse who was trained to complete rape kits. At the time, I didn't know. Those were called SANE nurses, but I learned it that day. And I was seen, so while I was waiting, nurses came in, they took labs to test for drugs and STDs, and to preface this, I don't remember what happened to me. I was told the next day. So they did all of the tests, and I waited for 3 to 4 hours to find out that they didn't have a nurse on staff to complete this kit. So I sat there and they took all of my vitals and everything for nothing, essentially, to make sure I was okay. But the hospital sent me across the street to a different hospital where the staff took me and immediately completed my rape kit. And all of the labs that the nurses took from that hospital went into my rape kit. Now, this rape kit would not be tested unless I pressed charges against my assailant, something I also didn't know at the time and I found out later on. I was advised against pressing charges during that time by the officer that took my statement because there was likely not enough evidence and I didn't remember what had happened to me. So due to this, my rape kit still sits on a shelf untouched. Weeks after my rape kit was collected, I called the first hospital to find my lab results that they had run to try to figure out some answers and get answers that I didn't have. And I learned that they never ran the labs that were ordered. My samples were nowhere to be found. So to this day, I have no idea what those lab results said or what truly happened to me. So during high school and college, I was provided education about consent and prevention when it came to sexual violence. No classroom taught me what to do following an assault. And my family didn't really talk about it because if I followed all the prevention rules like I was taught, nothing like this would happen to me, right? I did everything. I didn't take drinks from strangers. I was always with people I trusted, so this shouldn't have happened. So despite my many prevention tactics I was taught, I still became a victim that night. Fortunately, my amazing parents knew to bring me to the police and then to the hospital. I personally knew not to shower or to change my clothes, thanks to Olivia Benson in Law & Order SVU. A television show taught me more about this process than any institution. Additionally, I am a child and family therapist and case manager in Manchester, New Hampshire. So every single child and adolescent that I work with has experienced some form of trauma. I work with low-income families in the city. And the families that I serve are not always aware of their rights because they've never been taught about them or they're systemically taught to not say anything. They don't know that they can ask for a rape kit after an assault. These families need to be able to access a comprehensive guide to their basic human rights. So this is why this bill is so important. We need to be informed of our rights from the very beginning. Now, I can't change what happened to me, but I can work to change the system to ensure no one is failed again. No person should ever feel in the dark about what has happened to them. Changing the system from within is my justice. So I'm sitting here today as Brittany Lane, but I'm also Miss New Hampshire USA. I've competed for this title to bring visibility to an important subject that is often overlooked because it's uncomfortable to talk about. It's a very taboo topic. But the way we make change is by having conversations like we're doing today. I'm using this platform to share my experience and show other survivors that you're not alone, and using your voice can make a difference. It means so much to me that important decision makers like you are listening. So thank you all for giving survivors a voice today. Thank you so much.
Thank you very much for your testimony this afternoon. Are there any questions? Seeing none, thank you.
Thank you.
The chair will call Thomas Filardi.
Good afternoon, ladies and gentlemen. Thank you for having me. My name is Thomas Filardi. I'm an Associate Attorney General at the New Hampshire Attorney General's Office. For about 24 years before that, I was a county prosecutor. I was the Stratford County Attorney for a number of years. A significant portion of my time as a prosecutor was spent prosecuting child and adult sex assault cases, often against tremendous odds, and I appreciate the courage of the folks that have spoken here today. It's not easy to be able to articulate what has occurred to someone and then stand up and repeat it when called upon to do so. My testimony here today will be brief because there are other folks that will speak to other aspects of the bill. I want to speak to you about a very technical aspect of what could be going on here, and I want to direct you right to 1A, and the language that seeks to, quote, including any individual element or elements of a state sexual assault evidence collection kit. Now, this language would appear at first blush to be empowering language to survivors to be able to go in and give a history to their medical provider and request certain parts of a kit. I want to stress that in a courtroom, that would probably make anything that happens, medically speaking, inadmissible, because it wouldn't actually be a medical procedure. It would be evidence collection. If you look at what the Supreme Court does with these cases, and I've prosecuted hundreds of cases involving sex assault kits and litigated several up to the Supreme Court, it is not just important, but it's imperative that the collection of evidence be part of a medical procedure. Now, we recognize that the execution, the proper execution of a sex assault kit is a best medical practice. I've spent a majority of my prosecutorial career not only being on the Sex Assault Nurse Examiners Advisory Board, but also being the prosecutor that teaches medical staff how to execute a kit, what questions to ask, how to gain the proper medical history to be the legal underpinnings for how to execute the kit so that everything will be admissible in a courtroom, how to make sure we're taking that history without any sort of judgment or blame, also taking it thoroughly and completely and making sure that the survivor is able to narrate his or her true version of what occurred, and then making a medical decision based on that narrative. If you don't have those things in the proper order, it doesn't matter how well you execute a kit, none of it will be admissible in a courtroom because a judge, and if a judge at the trial level doesn't say this, the Supreme Court surely will say this was simply evidence collection. And that's not just me saying that, that's our New Hampshire Supreme Court. So a technical aspect of this that I would like to see everyone look at a little more is how can we make sure we're not creating language that would imply to survivors a right to do something which in the long run will fail them. We want to make sure that if someone takes the time, and I always said this to jurors, do you understand what it means to go through one of these kits, the hours spent, the difficult positions that have to be maintained just to execute the kit? Why would someone do this if they hadn't actually had that experience? Well, we don't want someone to go through all of those things and then tell them at the end of this, we can't have this evidence be admissible because it was evidence collection and not medically required or a medical procedure. So I just want to bring that to the committee's attention. There are other aspects of this, again, that other folks behind me will testify to. One other thing I would just highlight is I would really want to see everyone stay away from codifying in a statute any best practice. I've been at this for almost 25 years, and the best practices have radically changed. So I would, again, I'm here really more for information and just sort of cautionary tales from my own experience working in this field as much as I have. I want to say thank you to the sponsor for bringing this forward. It's an important dialogue to continue to have. I can assure you that there's no one in this room who is not interested in advancing victim survivor rights. That certainly includes myself. I would just like to see us be as constructive with what we're doing here as possible and not possibly create problems down the road and build expectations for people who, I'm going to agree with the speakers who came before me. Typically, in my role as a prosecutor, I am talking to people who are already beaten and feel as though they have been failed multiple times through the system. By the time they get to me, they don't really believe that I would have actually done anything for them. I don't want to build into the system yet another possible failure for them to have to overcome. So I want to thank you for allowing me to come and speak to you today. And certainly if there's any questions, I'd be happy to try to answer them.
Thank you very much for your testimony. Senator Chandley has a question, and then Senator Abbas.
Thank you very much, Madam Chair. Thank you for your testimony. And in your experience in both roles, have you come across doctors or other providers who did not know how to proceed in the event of a sexual assault?
Thank you for the question. As I said, I've spent a significant portion of my career, weekends, nights, whatever it took, to try to educate medical personnel about how to do an appropriate medical history taking to make sure that we are empowering folks to be able to tell what happened when they arrive. I have heard of stories as a SANE advisory board member of patients not being treated as well as we want to. I'm glad to say that those were not frequent. Of course, those are the ones that are reported. I recognize that there might be folks who don't choose not to report and simply walk away dissatisfied or hurt by the system. But from my own experience, I am not aware that there is an epidemic, if you will, of medical personnel who are turning away folks reporting a possibility of having been sexually assaulted.
If I might follow up.
Follow up?
In addition to the training that you've done and the training that I hope that most providers are receiving, is there anything else that you think would be beneficial?
I think an important aspect of when we talk about training is there's such constant turnover that training has to be every 6 months at the very least. I think it should be quarterly, but I can only get everyone to assemble twice every year. And I've always made myself available to continue to do that because there's always new personnel who need to be informed. And I tell them about some of the survivor stories that I've been honored to have them share with me and sometimes live with me through the court process. So when you humanize this and when you continuously do the training, focus on best practices and give real, not just emergency room, but courtroom combinations, I find that it becomes very helpful to avoid issues where you have medical personnel who are just not understanding what is really going on here and how can I provide good medical care. So it's constant training, and I've been proud to be part of that for a very long time and will continue to do so if I can ever be of assistance.
Thank you.
Senator Ravis?
Thank you, Madam Chair, and thank you for taking my question. In your experience, why is the court considering someone getting drug tested who feels that they were, drugged, with the intent to obviously cause them harm or to commit some type of sexual assault? Why is that not being considered a medical procedure? Because I would think perhaps if someone was given something involuntary, it could have complications with other medications they may be taking that are prescribed or allergic reaction reasons. I mean, it seems to me they're at a hospital getting a service. Why is that not deemed medical treatment? Because they can go to CVS or a pharmacy and buy an over-the-counter drug test. That's what they're looking for.
Sure. Thank you for that question as well. A lot of this is going to be based on the history that's taken. And there's, of course, going to be nuances there, which is why I've stressed in my prior testimony here today, you got to be careful about how you're asking the questions to take that history to try to get to the medical reason for taking a test or taking a swab or doing whatever you're going to do. So based on the history, if someone is tying that to a sex assault, and the time frame is appropriate for testing for those substances, I would have pause to question why this was not treated, that scenario would not be treated as a actionable medical examination to seek medical treatment cause of sexual assault.
Follow-up?
And somewhat off topic, but if someone is to report a sexual assault, I know last few years we passed a law that involved sex workers. If they were to report a sexual assault, they would be immune from prosecution, with a few exceptions. Is for a sexual assault victim, just in general, is there any immunity laws that you're aware of that would apply if they were to report it? Like, for example, if they reported a sexual assault and they had something in their, on their possession that happens to be illegal.
That's another great question. That's handled on a case-by-case basis. Prosecutors oftentimes will, of course, disclose that information because it is exculpatory, but then will seek to deal with that in a manner which is essentially immunizing that victim survivor from the added possibility of being prosecuted for possession of a controlled substance.
Follow-up?
Thank you, Madam Chair. When you say they're given immunity, is that the prosecutor is saying we're going to give you immunity in exchange for your testimony, as opposed to so they won't claim a Fifth Amendment privilege, or is that immunity by statute?
Oftentimes it's informal. In my own experience, it's typically been informal. A part of the dialogue We often, especially with teens and young adults, they're blaming themselves for putting themselves in a situation, and we try to take that blame right off of them. It's the alleged offender's fault that this occurred. And so we indicate to them oftentimes that it's most important to get to the truth. If you were using illicit substances that evening, just tell us, unless they actually have it on them, internal possession is not a crime. So oftentimes these things are alleviated well before we get to the point of saying, do we actually have a crime that you could be facing?
Let's follow up. I guess my concern is if in that scenario, if they were to be offered some type of immunity in exchange for the testimony, that would have to then be disclosed as potentially exculpatory as well. And perhaps that may, I guess, distract from the bigger issue at hand. So I'm just wondering if you agree with that or not.
No, in my own experience, because I've had to go through these machinations, I had a situation where I had a 14-year-old who had been vaginally or orally and anally penetrated over many, many times by a family member. And when I spoke to her about the possibility of the judge's ruling, we're going to have to talk about the fact that he gave you some cocaine that night, she laughed because it paled in such comparison to the traumatic events that she had been through. So I find that being honest and transparent with victim survivors and explaining this is where we're at, this is what the judge is asking us to do, we still believe you. You start by believing, and you indicate that over and over again to try to be reassuring that if you do this right, then victim survivors are willing to stay with the system. It takes a lot of work, but they have a right to have their day in court.
Thank you.
Are there any further questions? I have a question. If someone shows up at an emergency room and says, I've been sexually assaulted, are the police automatically called?
Typically, that would be occurring, yes. That would be a report of a crime, and they would be, the victim survivor would be consulted about having law enforcement. They can certainly do that kit anonymously. And speakers who are going to come subsequent to me will be able to answer the nuances there. I believe we're going to have the head of the same program, Janet Carroll, will be offering some testimony as well, and she can tell you how that actually unfolds.
Okay, I don't have her down to speak.
Oh, she might be accompanying someone.
My second question is there a set of protocols that are followed before a physician will do a rape test? I guess my question is, sexual assault occurs in a variety of different ways. So is there a protocol that you must have this, and this happen before we will do a rape test, a rape kit?
I think, Senator Carson, that they are looking for, is there a history that would fall into the need for, first injury, of course, acute or past, pregnancy, STD, sexually transmitted diseases. So they're looking for those things to say, what's the medical linchpin to be moving forward with doing any sort of further forensic testing. So they're roughly looking at a history that's going to include some sort of unwanted sexual either penetration or contact. Contact would be important because, of course, there is amylase testing, which would be contact testing for, if the offender's mouth or saliva came in contact with the alleged victim's body.
I think I'm a little confused here, because are you talking about the victim here, the person who comes forward and says, I have been assaulted, and they have to meet these criteria before they'll do a test? They'll look into their background? Did I hear you correctly?
They have to ask questions to take a medical history that would be appropriate to move into an area that would bring them to a sex assault kit.
To me, it just seems kind of odd, because if somebody reported that, I was robbed on the street, they would automatically go, okay, yep, we're going to get all this and we're going to get you taken care of. And now we're going to start going looking for the other guy, the person who did this. I don't want to say other guy, but the person who you claim did this. But in this instance, well, wait a minute, we got to look at the medical history. We got to do all that. It just doesn't seem that that is an appropriate response. I'm just struggling
Sure.
with this here to try to understand, how do you qualify? What are the qualifications?
When I say medical history, I just mean the patient's summation of what occurred, what brings them to the facility. So not past medical records.
Okay.
So the person comes in and says, this is what I'm presenting for. And then the doctor, practitioner, whomever has to go through the training and say, is this something that I need to be doing a medical procedure to intervene for that event? And if that event is contact or penetration of a sexual nature, then off they go.
I'm sorry, but I don't mean to be argumentative, but it just seems that there has to be qualifiers in place. I mean, if I cut myself in my kitchen and I'm bleeding and I cut my finger off or something, they're going to ask me about, are you allergic to any medications or all of those things. They're not going to question me about this. They're just going to take care of it and do what they need to do. But it seems like in instances where an individual presents themselves to an emergency room and says, I'm a victim of a sexual assault, now all of a sudden there's these buttons that have to be pressed before they will do a rape kit. I'm just, maybe I'm misunderstanding this whole procedure, but I don't see why anyone who presents at an emergency room claiming that they've been assaulted, sexually assaulted, why the protocols are different for them than they are for anybody else.
Well, the history does have to be different. You gave the example of showing your finger was cut, and that is, a laceration is readily discernible. But if you're talking about a kit which has, are we going to take fingernail clippings? Are we going to take pubic hair cuttings? Are we going to test someone's anus if there's no report of having been anally touched or penetrated? So you have to take a more detailed history because of the intrusiveness of what the kit requires. And there's good reasons for it, but you don't necessarily do every step in every kit. You would tailor that to what is the history. So the history is a little more intimate, which is why we ask that sex assault nurse examiners take that history and then have a doctor come in to do the actual examination after that.
Okay, I'm not going to be argumentative here. This to me just doesn't make any sense. If a person goes to the emergency room and says, I have been sexually assaulted, why they have to meet all these standards before that kit is even done just seems counterintuitive, especially for medical care. We had testimony that the representative believed she had been drugged. Why didn't they do that, and why wasn't that processed? At some point, somebody along the line made a decision that we're not going to do anything with this. And I guess that's where I want to get, to try to understand how someone can come in and say, this is what happened to me, and then over here says, well, we're not going to do anything with it. For me, that's the missing piece here. And I'm trying to find out, how did that happen? Because again, if somebody shows up for any other reason and says, I'm here for this, they would take care of them. Why wouldn't they do it in this instance? And that's, I think, what I'm really trying to find out.
Sure, no, I appreciate that. And there are going to be nuances to how someone is able to articulate that history about what occurred to them. And I just can't answer that more fully.
All right, thank you. I appreciate it. Senator Abbas?
Thank you, Madam Chair. Not that I'm oversimplifying this, but if someone were to go to an emergency room, if they simply just reported that they've been sexually assaulted and then asked for this kit to be performed, would a policy like that just basically automatically triggering then the procedure be sufficient to maybe bypass some of the, I guess, question that goes into this?
Again, the testimony that comes after me, I think will probably help amplify this. It's just going to be more important to ask those follow-up questions to understand what are we actually going to be testing for. I've had kits where people have walked in and, typically accompanied by police who are asking, will you please do this part of the kit? There was an elderly woman who had been sexually assaulted by a neighbor. And she had indicated that this young man had placed his mouth on her breasts. And so we got a little bit of resistance from the police department, from the hospital to perform those tests where we had a police officer there advocating, please do this part of the kit. She has reported this. And so sometimes, I do understand, sometimes there is some resistance by medical people. That's why I've devoted so much of my time. That was the impetus for me to devote so much of my time to do trainings. To say you've got to start by believing and take a thoughtful history to get to where you need to get to for your next medical step. But there is a next medical step to take. Someone is reporting a sex assault. So get to what that is and how to treat it.
Are there any further questions? Seeing none, thank you very much for
Okay,
your
thank you all very
testimony.
much for your work.
And I apologize if I appeared to be a
No.
little argumentative.
No, these are important questions to ask to understand the scope of the issue. Again, I do hope this goes somewhere. I've brought to you my concerns, but certainly not my negativity towards the issue. I hope you can tell that from my testimony. Thank you.
Thank you. The chief will call up the chief. The chair will call Chief Alex Lee.
Good afternoon, Madam Chair and honorable members of the committee. My name is Alex Lee. I'm the Chief of Police in Newport, New Hampshire. I've been a police officer in New Hampshire for 20 years. A majority of my career was spent as a criminal investigator, a detective specializing in adult and child sexual assault investigations. I also serve on the Sexual Assault and SANE Advisory Board. The purpose of that board, it's a multidisciplinary board that includes medical professionals, law enforcement, prosecutors, and other professionals that work in this space. And as a board, we consult on what are best practices in sexual assault investigations. We make recommendations for changes to the Attorney General's model protocols, both for medical staff as well as law enforcement. And that protocol and those best practices, as Attorney Velarde indicated, have changed over time based on technology and training and new knowledge and research. So I'm going to go out of order with my testimony a little bit to try to address Senator Carson's concerns first. Every case that we deal with is different, and every single case that we investigate calls for different evidence collection strategies, different investigative strategies. And when a person reports a crime, whether it's sexual assault or another crime, law enforcement officers, investigators, and prosecutors discuss and come up with a strategy for that investigation to try to develop the strongest and most robust evidence that we can, depending on the facts of the particular case. So in the case of a sexual assault evidence collection kit, as Attorney Velarde said, there are many, many different components to that kit, and not every component to that kit is likely to produce probative or relevant evidence to the reported crime. Different types of DNA, different types of bodily fluids, different types of forensic evidence that could be gathered in a kit. We know from the experts and the scientific research that that evidence is available for different periods of time, depending on whether it's a chemical substance in the person's body or a bodily fluid that's being collected with a swab. And so part of our job on the SANE Advisory Board, when we're developing the best practices, the model protocols for evidence collection, is to listen to the director of the forensic lab and the criminalists at the lab tell us, here is the technology that we have available today, here is the types of evidence that we can test for, and here is the window of time in which we would expect to actually find that evidence. So, for example, if the experts at the lab tell us that a certain type of DNA is only going to be present on a person's body for, let's say, 48 hours, and a victim presents reporting a sexual assault that occurred 96 hours ago, it would not be beneficial to collect that type of evidence in that case if the likely result is that it's not present. In fact, that could be used by the defense at trial as exculpatory. what the victim reported did not happen because the police collected evidence and the lab said it wasn't there. So we try to tailor our investigations and what evidence we collect to the specific facts that the victim reports as to what happened to them. As another example, as Attorney Velarde said, if a victim reports a sexual assault that involved vaginal penetration, then perhaps an anal swab is not appropriate to that case because we don't expect there to be probative or relevant evidence there. So to get back to what I plan to testify to today, we determine what the best practices are based on consulting with experts, and we provide that model protocol guidance to both medical professionals and law enforcement for what they should do in different types of cases depending on what is reported and what evidence we expect to be there. Indiscriminate collection of evidence where we look for the same evidence in every single case regardless of the circumstances is not necessary, and it's not helpful to an investigation or a prosecution. In fact, sometimes it can be harmful to a prosecution by producing unnecessary exculpatory evidence. I have personally investigated cases that are not dissimilar to the fact pattern that Representative Reed testified to today, and law enforcement has tools to collect relevant or probative evidence in those cases outside of the traditional SANE kit. So for example, if Representative Reed had come to the Newport Police Department to report that same fact pattern to me, after checking the model protocol, if it appeared that the standard SANE evidence collection kit did not meet the circumstances that she's reporting, what I would have done as the investigator in that case is used what we call a legal blood draw kit. The Department of Safety provides all police departments canisters to take legal blood draws in different types of investigations, whether it's a DWI or some other crime. And I can, with the victim's consent, bring the victim to a medical facility with the legal blood draw canister, and I can request that the medical facility take a legal blood draw for law enforcement with the victim's consent, and then I can send that kit to the State Police Forensic Lab or a private forensic lab for toxicology testing to collect the evidence that's important for that particular fact pattern. So you don't have to meet certain qualifications. There isn't an entrance test to receive medical treatment, or there certainly shouldn't be. However, what evidence should be collected in what cases, whether it's most appropriately done through the traditional SANE evidence collection kit or one of the other law enforcement tools that we already have available, really just depends on what the person reported, what the facts are, and what evidence is most likely to be available to us and can be collected and tested with positive results. And we already have the means to do that. Less important than what I just testified to regarding indiscriminate testing and the harmful nature that can have to cases. Also, the collection and testing of forensic evidence is very expensive, both on the collection side and on the testing side. And that expense is completely worth it when it is likely to, or when it results in positive probative evidence that we can use in court. So we never use the expense of collection or testing to deny ourselves relevant evidence. We will spare no expense in those cases. However, indiscriminate testing that is not likely to help a case is going to take resources away from that limited pool of resources that we have for other cases and other types of investigation and evidence collection. So in the town of Newport, if I have budgeted $10,000 for private laboratory forensic testing, and throughout the first 6 months of the budget year, we send 7 or 8 unnecessary samples to NMS labs in Pennsylvania for testing, and I consume my forensic testing budget through that. When the next case comes in that's really important and it's likely to produce relevant evidence, we want that money to be available to do that. Additionally, small police departments, such as mine particularly, we already struggle to store the same kits that we already collect. According to the state statutes, in some cases, we have to store these kits for up to 40 years. And we have limited ability to do that already. And again, we would spare no expense to store, as appropriate and required by law, kits in situations where the collection of those kits is going to help a case, but to, again, indiscriminately produce extra kits that are not going to produce helpful evidence in a case will only aggravate the problem that we already have to store kits. So for those reasons, I would respectfully request that this body allow the professionals and the experts that work in this field to determine what the appropriate standards are, what the model protocols and the best practices should be to provide the best results for victims and for the administration of justice, rather than attempting to codify those best standards in a bill such as this one. And I'd be happy to take your questions.
Thank you very much for your testimony. Are there any questions? Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question. You mentioned that in a circumstance, you heard an instance that was a previous witness testified to, you would have had that blood eventually sent to a laboratory for testing. The results of that test is, for it to be considered positive, is there a certain measurable amount, like similar to someone on like probation who flunks a drug test, or would just traces of a substance be enough to trigger a positive test in a case of investigating a sexual assault?
Thank you for that excellent question. The different substances have a different half-life, meaning they metabolize in a person's system over different periods of time, depending on what that substance is. So some substances metabolize very, very quickly in blood, and a positive test result would not be available after a very short period of time. Other substances will take a much longer period of time to metabolize, and we might still be able to find metabolites of that substance after many days or even weeks. So what substances a person might have been administered and in what quantities or doses will depend on whether we'd be likely to get a positive test result. So even in the case of taking a legal blood draw and sending it for testing, whether or not we would do that would have to depend on the circumstances. A person that reports an attempted sexual assault or an attempted drug-facilitated sexual assault within 24 hours, we would be very likely to be able to find metabolites of that substance in the person's blood, and sending it out for testing would make sense. If a person reported it 6 weeks afterwards, then we know that it is very unlikely that there are any metabolites of a particular substance in their blood, and then that type of collection and testing would not be called for.
Follow-up?
What I'm getting at is, if someone's tested for, like, let's say, cocaine, right? There's a certain measurement they're looking for to basically pass or fail you. But there are instances where they may pass, but if you look at the details of the test, they essentially are lucky with their timing, shall we say. Meaning they were just a fraction under the amount, but that amount's unlikely to be in your system if one didn't use said substance. So I'm saying the test will come back as a negative in that case. And normally I would have to request a more detailed results. I'm saying if you're investigating a sexual assault, maybe the results come back negative, but there's still traces of, let's say, GHB or something in someone's system, which would be unusual to have in your system. So what I'm trying to get at is, when you do your investigation, the results that come back, is there a measurement of these substances that they have to detect for it to be considered positive, or do they just give you the detailed result saying this is in the system, interpret it as you wish?
Thanks for that question. So there are sort of a two-step process to toxicology testing. An initial screening test, which you're correct, there's a minimum level that is required to trigger a positive result. And then there's a more detailed confirmation testing process. And so we do have the means to request a lab if we know from case facts that we suspect a particular substance. We can ask the lab to perform more detailed confirmation testing for that particular substance, and we do that when we have sufficient information to allow us to do that.
Thank you.
Are there any further questions? Chief, I got a couple of questions. You had mentioned model protocols. Would you be willing to supply the committee with a list of your department's model protocols? I understand that every police department will do something different, and I'm wondering if there needs to be consistency across every single police department. So if someone finds themselves to be a victim of sexual assault, it doesn't matter if they go to your department, they go up north to Berlin, they come down to Londonderry where I live, they're going to be treated the same. So if you could do that, that would be, I'd like to see that. My second question is, you talked about the tests that are done, and if the hospital refuses to do the test for any reason, is the victim given the opportunity to have the tests done at their own cost, or have their insurance pay for it? Or are they just automatically denied and say, no, we're not going to do this?
Thank you for your questions. Regarding your first question, the model protocols that I was referring to are generated and issued by the New Hampshire Attorney General's office to all police departments throughout the state of New Hampshire. So I'm pleased to tell you that every police department in the state of New Hampshire is operating under the same protocol when it comes to best practices for sexual assault investigations. And that model protocol that's issued by the Attorney General to police departments is one that we revise through the recommendations of the SANE Advisory Board based on updates in testing and technology and case law. So, for example, if the protocol previously said that a certain type of swab could be collected within a 3-day period, but then a new piece of technology arrives to the lab that says now we can find that same evidence over a 5-day period, then the SANE Advisory Board would make recommendations to the Attorney General's office to amend the protocol and say, let's expand the period of collection for this type of evidence based on that new technology.
I'm sorry. If you need to continue,
I was going to move on to your second question, but if you had a follow-up to that one. I'm sorry, what was your second question?
My question was, if a victim presents and the doctors do not want to do a test, do you think that the victim should be asked if they still want the test, but they have to pay for it either by insurance or some other reason, or some other way to pay for it?
Thank you. I guess I can only answer your question from the law enforcement perspective. And as a law enforcement officer, if I'm investigating a reported sexual assault or attempted sexual assault, and there is a certain type of evidence that I feel is necessary for my investigation and for prosecution, I would request that the medical professionals collect that piece of evidence regardless of whether they felt that that was a medical necessity or not. And in my 20 years of experience, I've never had a medical professional refuse to collect a piece of evidence that I requested with the victim's consent.
I'm just trying to figure out where the victim fits into all of this. Because of the testimony that we've had, it seems that they're kind of put over here. And you've got all these protocols and rules in place, and we keep forgetting about the victim who's over here. And they really should be up front, not being placed somewhere else while all these protocols are trying to figure out what to do. But I just have one more question. You had talked about these model protocols. I know that our police officers, we've now created a program of accountability. I've worked on that particular board. And do you know if police departments, the ones that have voluntarily signed up right now, it's voluntary, are they being held accountable for adhering to this model?
Yes. So first, when a new police officer is hired and is sent to the police academy, they're first trained on the model protocol for sexual assault investigations as a recruit at the police academy. And then after graduating the academy, over the course of their career, every year they have to complete continuing education and in-service training hours that includes updates and refreshers on the model protocol. And they're sent to also more advanced training if they choose to become a detective or an investigator that would go beyond even the minimum requirements of the model protocol. So there are systems in place to make sure that our police officers are properly trained in what the protocol is and any updates in that protocol. I think what you were referring to is the new New Hampshire accreditation program. And in order to be accredited by the Police Standards and Training Council, you have to provide proof to the PSTC that your internal policies in the department comply with best practices, comply with the model protocol, and you further have to provide supporting documents and case files showing that your department in fact follows those policies. So if a department does not follow best practices and those policies, then they would certainly be at risk of not receiving accreditation or losing their accreditation.
Thank you for that. My concern is we hear a lot about victims who fall through the cracks of our judicial system. And do we need to create a safety net so that victims of sexual assault do not fall through the cracks and forgotten, whether it's the victim themselves or the rape kits? Because we've heard about other places around the country where women have reported their rape and a kit is done and then it's piled someplace and it's never looked at again. So I just want to make sure that we are providing the best possible service for victims of sexual assault.
I completely agree with you in that regard. And we are, as the SANE Advisory Board, constantly working to improve our response to these cases. We do a case review quarterly with the forensic lab, with SANE nurses, and with members of the advisory board discussing specific cases where things fell through the cracks or were not done according to best practices. And then we make adjustments to our training. We make adjustments to the guidance we're putting out to both medical practitioners and law enforcement. So for example, at our quarterly meetings, the criminalist from the laboratory might say, I had these cases where certain pieces of evidence collection were packaged and sent here improperly, so I wasn't able to test them. And then as a board, we say, okay, we need to send out guidance to all of the SANE nurses that they need to collect the evidence in this way so that it will be properly tested. There have been cases where SANE nurses have reported to the board that law enforcement didn't respond to the hospital to pick up kits in a timely manner. And so as a board, we discuss how do we get that message out to law enforcement that this is absolutely critical for them to do. And we might have the Attorney General's office or the county attorney's offices send out letters to law enforcement agencies. So we are constantly receiving feedback about deficiencies in the system and in our processes, and we talk about how best to improve those deficiencies, including over the past year that House Bill 378 has been pending. The board has had discussions about the concerns that were brought up and how as a board can we respond to those and how can we improve the model protocols. So I agree with your principle about not leaving victims aside and listening to their concerns. I just personally don't feel that codifying in legislation the way that this particular bill was proposed is the best way to bring those improvements.
Okay, thank you very much. Are there any further questions? Okay, seeing none. Thank you again, Chief. Appreciate it. The chair will call Pamela Kylig.
Small,
I'm also bringing up my colleague Janet Carroll.
Okay, just note, please, if you're both going to speak, before you speak, you identify yourself for the record.
Absolutely. Thank you. Good afternoon, Madam Chair, members of the committee. My name is Pamela Keilig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. I'm joined here by my colleague Janet Carroll, who is one of the directors of the Sexual Assault Nurse Examiner Program at the Coalition. And I'll speak first really briefly and then turn it over to Janet, and she'll further introduce herself. We're here, as you know, the Coalition is the umbrella organization for the state's 12 community-based crisis centers that serve more than 14,000 survivors of domestic and sexual violence each year. And we are here, unfortunately, to raise concerns to HB 378. I think you've heard some of them already here this morning or this afternoon. And I think we just really wanted to touch briefly on the medical side of the forensic medical exam, because I think it's really important to understand that there's both a medical component and then also a criminal component or a forensic component. We just feel that more work needs to be done before we can move forward with this proposal. As you've heard, it's a very complex and collaborative process, and we just really want to make sure that all the appropriate pieces are in place before we make any changes to the statute. But we're happy to continue to collaborate and work on solutions. As you've heard a little bit this morning, New Hampshire adopted the Sexual Assault Survivors Bill of Rights, RSA 21M18, in 2018, following the passage of a 2016 federal law. So New Hampshire is one of more than 20 states to adopt this model language at the state level. The goal of this legislation was to set a standard for states to replicate at the local level and to establish a transparent process for survivors to seek justice. It was also established to ensure that sexual assault survivors' rights incorporate best practices regarding medical treatment, evidence collection, and the preservation of information. RSA 21M18, the Survivors Bill of Rights, governs the rights afforded to sexual assault survivors, including a victim's access to medical forensic exam free of charge, having evidence preserved, being informed of their rights and the results of the evidence kit, and getting those written policies governing the collection and preservation of those kits. So it's, although short looking in statute, it is actually very comprehensive, and it reflects the model protocols that were mentioned earlier today. There have been several iterations of HB 378 since it was first introduced in 2023. And while we appreciate the ongoing efforts of the sponsor, this bill still does not really address a lot of the concerns and further complicates the issue. As a result, there could be unintended consequences for survivors when they seek access to medical care and justice. And so we really just hope that the committee will consider all of the testimony that was brought forward today and just understand that this is a very complex, nuanced, and comprehensive process. And with that, I'd like to turn it over to Janet.
Thank you, Ms. Kelly.
Good afternoon. For the record, my name is Janet Carroll. I've been a registered nurse for over 24 years. I've been a sexual assault nurse examiner since 2005. In addition to my role at the Coalition, I'm also the nurse manager of the busiest forensic nursing program in the state of New Hampshire. I've provided thousands of these exams personally, okay? In addition with those roles, I also serve as the co-chair for the New Hampshire Sexual Assault and Nurse Examiner Advisory Board, which you've heard much about already. The board is consisted of many representatives from the Attorney General's office, the Coalition. There are SANE nurses, physicians, healthcare organizations, corrections, law enforcement, prosecution, several among others, okay? The protocol is developed by that particular advisory board, the medical forensic protocol. It's critical as it governs the response of the medical professional to the care and treatment of sexual assault patients. The acute care protocol has been in place for several decades and is posted and followed in all of the New Hampshire hospitals, okay? Each year we complete between 200 and 300 sexual assault evidence collection kits at the hospitals in New Hampshire. We have protocols in place for a reason, and the healthcare providers throughout New Hampshire are educated on the process and the procedure associated with caring for those patients who have experienced sexual assault. That protocol, as you heard from Chief Lee, is updated and revised. It's currently going through revision at this current time. The protocol is also designed to work in tandem with RSA 21M18. The statute and protocols are well-written and sensitive to the patient's needs. They are also used as a model by other states across the country, and they mirror the best practices set forth by the national protocols and best practices. So, as medical clinicians, when a person presents to an emergency department, any patient, we have to collect a medical history of, what they're coming in for or what they've experienced for medical diagnosis and treatment. Okay, so meaning we're going to provide our care based on the history that was provided by our patients when they presented in front of us. Okay, so when a patient comes in and they provide a history where they believe there was suspected sexual assault or there was a concern or reported for sexual assault, our goal is that we make sure they're medically, physically, emotionally healthy and that they're safe. If there's a concern that the sexual assault, occurred or there was a concern for it, we would provide them with several options. Okay, that is what the protocol is. And the first option is, a medical forensic evaluation without any evidence collection. So that would be documenting a detailed history of what they experienced that led to their visit. We can look their bodies over head to toe for any injury or disease process. If they have injury, we can offer them photography if that's what they want. If they're concerned that they would become pregnant as a result of the assault, we offer pregnancy prophylaxis. We also offer them medications to prevent the transmission of sexually transmitted infections and HIV if those are applicable to their particular assault. In addition, obviously, is, with the coalition, we also offer our patients advocates from the local crisis center. And if they feel they need to talk to someone from mental health, that should be allowed as well and offered. Okay. The other options that they are provided, given the history from the patient reports sexual assault did occur or could have occurred, they are offered two options which involve evidence collection. One would be reported evidence collection. So everything, all those medical needs that we talked about, reported evidence collection would be, Concord Police, we have Janet Carroll here, she was sexually assaulted and we'd like to, she would like to report this crime to you. And they would collect the evidence from us after we've collected it and start their investigation. The other option that is offered to patients when they present to New Hampshire hospitals is anonymous evidence collection. So, if a person's been through a lot, if they're traumatized, they might not know what they want to do. There might be many nuances to their history. They might say, you know what, I'm not ready to report, but I'd like my evidence collected. And in that event, we would do evidence collection. That patient would be assigned a serial number associated with the kit. We would collect that evidence. We would discharge the patient or admit the patient if that is what's needed. And then we would call the police department and say, hello, Concord PD, we have an anonymous sexual assault kit for you to pick up. And they will collect it from us and they will preserve it and store it. Okay. And then it would be up to the patient to call law enforcement in the town that it occurred in order to report their assault and say, hi, Concord PD, I'm Janet Carroll and I'm number 9,000 or whatever the number might be. Okay. In addition to that, so those are the options that are provided. And I'd like to talk about drug-facilitated sexual assault. So if a patient presents stating that they felt they were drugged and that a sexual assault did occur or may have occurred, there is a process already in place to respond to that. Okay. If a patient presents within 24 hours of being drugged, blood would be collected. If a patient presents within 120 hours of being assaulted, urine would be collected. Okay. Those samples then would be transferred to law enforcement having jurisdiction over the case. And if the patient reports to law enforcement the police department would eventually send it off to the New Hampshire State Forensic Laboratory for analysis. Okay. In the hospital setting, we will treat and provide care based on the symptoms that they're presenting. So that's like the medical care, which may not include a standardized urine toxicology screen. So to answer a question earlier, what's the difference? So In the hospital, if we were to we really only have one toxicology option for testing for the most part, and that's a standardized urine toxicology screen, which only tests for 6 to maybe 9 possible substances in the body or classifications of drugs. The testing that goes off to the forensic crime lab is hundreds of chemicals I can't even pronounce. So the other thing that Chief Lee also touched on is there's many different variables to that. It depends on what chemical was introduced to the body, on how long you actually might find it in the body. For example, GHB is in and out of the system within 4 hours from the time of ingestion. So sometimes you might actually get false negative tests. So it's very important for us as clinicians to document what signs and symptoms they might have experienced. And that in itself is evidence. We don't necessarily need testing done as well, okay? Let's see, I went off script a little. So ultimately, that is that. If a patient presented to the emergency department and said, I think I was drugged, but there's no way that sexual assault occurred, that would be a different type of protocol, okay? That wouldn't necessitate a sexual assault medical forensic evaluation because the act of sexual assault did not occur. So it really goes based on the history that was provided at the time the patient came in, okay? And law enforcement, as you heard, has a completely different process than what we can do at the hospital. The medical forensic protocol is posted and followed at the hospitals, okay? Medical clinicians are provided free education to the protocol. Annually, the coalition provides a minimum of 3 comprehensive sexual assault nurse examiner courses in the state of New Hampshire. That's where I was today. That is offered free of charge to registered nurses, physician assistants, and physicians if they want to take that. In addition to that, we also provide regular quarterly education to New Hampshire medical professionals on topics of sexual assault. Those are free of charge. We offer case reviews every other month on sexual assault cases, as well as mock simulation exams should they feel that they need exposure to more cases. In addition to that, emergency medicine physicians receive training on sexual assault evidence collection kits and protocols in their residency training. So I've been doing these exams for a very long time. I've completed well over 1,000 of these exams, and I'm very proud, especially when I hear from other states, the response that is done in New Hampshire compared to other states. I'm proud that we have a very strong working relationship with our partners. In my career, I've heard a lot of violence. I hear it, and I wish that violence, abuse, pain, suffering was not in New Hampshire. Unfortunately, is. And as a SANE nurse, as a member of the coalition, I strive to ensure that when the patient's leaving the hospital, that we've provided them with the resources to heal, that we've addressed their medical needs associated with sexual assault, and that our medical clinicians are responding in a trauma-informed manner to the reality of what they've endured.
And a couple of things that came up as Janet was testifying. I did want to note that recently we've launched a statewide kit tracking system so that every kit that's processed comes with a QR code so that the status of the kit can be tracked. And that process is regularly updated. And I can't speak more to the details of that, but I know it's been launching across the state over the last few years. And we're very proud that that's something we have in the state. I also just wanted to note if there are more questions regarding the forensic lab process. I knew a representative from the lab is here today. I know we covered a lot, but mostly we're just really grateful for the committee's interest and investment in ensuring that the rights of survivors are followed and adhered to in the state. And we'd be happy to answer any questions. And thank you for your time today.
Thank you very much for your testimony. Are there any questions from the committee? Senator Abbas.
Briefly, if I was outside and didn't hear you, I apologize in
It's all
advance.
good.
But thank you for taking my question. I asked that the police officer testified about the results of the kit, and I just know that sometimes someone may test negative. It is certainly not always the indication that they didn't actually use something or ingest something, but just the measurement just happens to be lower. I'm just wondering if someone were to be tested for an involuntary substance that they may have ingested, will it just come back negative based on a certain measurement, or is it, if there's traces of, let's say, GHB in the system, would that come back as a positive just because of the traces?
I would not have the answer to that. The testing that goes out to the forensic lab with the state police, they get the results of those. I actually do not ever see the results of the evidence that's collected or the blood tests that are completed by the forensic lab. The ones that are completed in the hospital are traditionally are positive and negative. But again, that would be for a laboratory technician in order to answer those questions. I wouldn't have that expertise.
Follow-up?
So in my experience, the initial result is one thing, but if you request the record of the test, then more detailed measurements will come in. Because obviously if it's a negative test, it's really a positive and negative. So if you request that, what I'm getting at is will the police officer investigating even see anything more than it's a merely negative?
I would not know the answer to that question, unfortunately.
Thank you.
Yeah.
Okay, are there any further questions? Okay, seeing none, thank you both very much for your testimony this afternoon. The chair will call Representative Leon.
Thank you, Madam Chair, and thank you for allowing me to come back. I think my day today is very similar to what you experienced yesterday. For the record, I am Representative Erica Leon. I represent the town of Derry, and I'm the Vice Chairman of the House Health and Human Services Committee. This bill is important to me because I think you all understand that rape isn't about sex, it's about power. And if you've been raped, being able to regain your power is one of the first steps to healing. Understanding what your rights are, having those validated is absolutely key. When we had this bill initially come to us, one of the big concerns was that attempted rape isn't in our statutes. And that's correct. Attempted rape is not in our statutes. But we have 3 levels of sexual assault. We have felonious aggravated sexual assault, which is what you would traditionally think of as rape. We have felonious sexual assault, and then we have misdemeanor sexual assault. So basically anything that would be felonious sexual assault, if it's just sexual contact, which means not penetration, but it's contacting one of those areas that we view as sexual areas, done either for humiliation or sexual gratification of the person doing it. That is a misdemeanor. That is sexual assault. And finding people when they're only at that level, whether it's because their intended victim got away before there was penetration, or because they're slipping something in somebody's drink and feeling people up, I think we should make sure that we have the evidence to catch them early. As we walked through this bill and walked through those policies, I read through both of those guidance documents. Some of you may know I like details. It took me a long time to get through those and get to all of the details and processes. I realized between the testimony that we heard, which was quite similar, and my own research, that it's very important that we don't create anything new. We have a fantastic system that outlines a very good policy and procedures. It's one that's updated to make sure that it reflects best practices. But within that, it lays out every single item that we included in this language about what should be given to a survivor. This guidance document says how long after an assault samples, including blood, urine, and other evidence, are generally collected. Rather than us putting that into statute, this basically adds a parallel document. When they're adopting these procedures and protocols, you have the detailed one that the police departments, the SANE nurses, everybody who's involved in this care needs all of the details. But this is an executive summary. This is a summary sheet that the same group would then make that would make it so that people can understand their rights. If you look at the bottom of page 2, in section 3, the existing language on lines 28 through 32 are what enables the Department of Justice to have our standardized rape protocol and KIT and domestic violence protocol. This adds a new section saying that they just need to have a summary document. And then the bill further says that that summary document needs to be available. You know, it's a little bit more work having to summarize it and make it so that people can understand their rights. But I'd say I'm pretty good at reading rules. I'm pretty good at reading procedures, but it was hard for me to tease out all those necessary parts. And quite frankly, as this is being put together, those highlighted 1 page or 2 page of information is key because people's eyes glaze over, especially if they've just been victimized. And so charging the Department of Justice with having something that's simple and easy to understand starts to heal that the fact that the victim, the woman or the man, because men are also victims of sexual assault, that woman or man begins that path to healing because they have the power to know that, no, this is what happened to me, and I have a right to ask for this. I know it's in law, I know it's in the procedure, but right here in the rules, it says because this happened, and it'll cite something, they'll be able to cite something that happened to them in their assault. I deserve to get this kit. Our law already says they have that right. This just helps empower people in one of the most vulnerable times in their life. If there are ongoing concerns with this, I spent most of the last year working on trying to get the right language. If you want to work to see if there's any continuing problems with this, I would love to work with you. But I think that this has actually distilled it down to have minimum information that needs to go through the rulemaking process to give this information sheet. There will still be opportunity for public comment from people, from the chiefs, from the SANE nurses, from the public, from legislators, from any involved people within that process of when they formulate that sheet of information. So this isn't final. It's done through rules and it's updated as it needs to be. There's the language that I know may concern people. I apologize that I had to step out for another meeting. People were waiting on me. But I'm assuming that the language that spills from page 1 to page 2, starting on line 26 to line 3, was a bit of a concern for people. However, that's all existing law. If you've been subject to an offense from the felonious sexual assault, the felonious aggravated sexual assault, or the misdemeanor sexual assault, you have this right. Not everybody knows that it's not just penetrative. We actually had testimony in our committee that if you were not penetrated, you did not deserve a rape kit. I hopefully those words have not been spoken since, and hopefully people have learned from that. But that was the mindset and that was the expectation. But our law says that if you haven't been penetrated, but you have been groped, especially if you've been drugged, that you do have a right to that kit. The other is to make sure that if somebody says, somebody tried to rape me, and they don't know the right language, that just because attempted rape isn't in our statutes, misdemeanor sexual assault, which often encompasses the characteristics of attempted rape, are. And just because somebody in a time of crisis doesn't know the right words, they shouldn't be withheld the kit. So I think that this is absolutely crucial. I like the language that we put together in my committee. I think we did a good job. But if you don't agree and you want to work on it, I'd love to work with you. And I really hope that we can have your support so that we can tell victims that, no, you get your power back. And that power and knowledge isn't just in the experts at the SANE nurses and the police chiefs, but that knowledge can be disseminated. A sorority can have it on their wall. A sober home can have that information posted. So in a sober home, if people are victims of sexual assault, they'll know what their rights are. They'll know that they have a right to be tested. They know that they have a right to evidence collection, and they know that their voice matters. So by having that available, we can empower people and turn them from being victims into being survivors. So I'll take any questions.
Thank you very much, Representative. Are there any questions? No questions?
Thank you.
Thank
Hopefully that's a good sign.
Okay. Are there any other members of the public that would like to speak to House Bill 378? Sure. Come on, sit down.
Thank you, Madam Chair and honorable members. Again, I don't know if I have to do it again, but my name is Ellen Reed. I represent Rockingham 10, Newmarket, and Newfields. Some of the things I wanted to address, some of the things because I think there was a lot of muddying done, a lot of talk about what would happen in a certain case because these are the protocols and this is what we strive for and best practices. Specifically, I think what we heard very sadly is how many times the actual law, the rights of survivors is violated by the people in authority, because you heard a lot of examples of when we wouldn't offer a kit. We wouldn't offer a kit. If you turn to the handout, that's the existing RSA on the third page. That's section 21M18. Line A, this is the very first right that we guarantee sexual assault survivors: the right to not be prevented from or charged for receiving a medical examination. They're talking about when they would not allow, when they would not offer an element of that examination. That's already in law. We already guarantee that. So what the opposition to this bill is actually saying, and this is very crucial because we heard, what was that, 2 hours of, well, this is best practice and this is what we would do and this is what we would do. The only thing this bill does is make sure that the victim is informed of what their existing rights are. So opposition to this bill is essentially saying it's great that we have those rights, but we don't want to let the victims know that the rights exist. That is what the opposition is saying. Now, I understand that perhaps there's, and by the way, this sexual assault survivors' rights 21M that we passed several years ago, this was RISE. RISE is the motivating force, the organization that's supporting this bill, that's strengthening it. RISE was the motivating force behind, and I think the coalition said there was something like 20 states. They were incorrect. 43 states have adopted this exact language that we have. So with that, I just wanted to bring it back to the point. The only thing this bill does is specify, and there was something about it has to be part of a medical examination. It says in the existing law, from receiving a medical examination, including the kit. The other piece is that to be informed in writing, including RSA M19, which already exists. And the third change is defining sexual assault survivor. You heard something about kits being taken for reasons that would be not real crimes. That's not true, because right here we are defining and referencing the actual definition of sexual assault: felonious aggravated sexual assault, felonious sexual assault, and misdemeanor sexual assault. It's right there, it's referenced. So there's no running of kits that aren't needed to be run. So all this is doing is those 3 minor changes to clarify the existing situation we have, and then saying doctors have to tell their patients that they have these rights. The problem is all the examples that you were given about, well, if this happened, if somebody reported having this happen, then this is what would happen. And there haven't been very many complaints about SANE nurses. No SANE nurse was called for me because the doctor didn't know. No New Hampshire law enforcement officer was called. I wish a SANE nurse had been called. I wish a law enforcement officer would have been called to that hospital, because they would have told the doctor that, yes, I had a right. But they didn't. They weren't called because the doctor didn't know. And so really, by doing this, by requiring that there's a brochure that's made in rules that can be changed if best policies change, by requiring this, what we're actually doing too is informing and educating doctors who are not going to read the 200 pages that I already sent to you. So I just wanted to bring it back around to the point. The point is, no one should be saying, yes, it's great that we have rights for victims, but we don't want those victims to know those rights. And so if there's anything that needs to be changed, I'm happy to help, as are the other representatives and Representative Leon. But I think not informing victims of their rights is not an option. And thank you for taking me again.
Thank you very much, Representative. Are there any questions? Okay, seeing none, thank you. Are there any other members of the public that would like to come forward to speak to House Bill 378? Okay, seeing none, we're going to close the public hearing. The committee will be in recess until 20 after 4.
20 after 4?
Yeah, it's 10:04 now.
I don't think we need that much time.
Okay,
Till 4?
that's only 10 minutes. Make it 20 minutes. 10 after 4. Okay, the committee will be in recess until 10 after 4. There we go. We'll negotiate that. Daryl, Senator. the committee will come out of recess. Can I get a motion to go into executive session? Moved by Senator Gannon, seconded by Senator Whitley. Okay, the first, you should have your list. The first bill we're gonna take up is House Bill 1314. I'd like to move in, interim study.
314?
Yes, 314. So I've moved interim study and Senator Gannon has seconded. Okay, discussion.
I will just say, I can support that. I think, we passed SB 255.
Mhm.
We need to see that through.
Yeah, we had a long list of people who were, did not support this bill, so I think an interim study motion is appropriate for the sponsor to go back and take a look, and if they decide they want to bring it in, at least they know what the arguments are. So, okay, so we have an interim study motion. All in favor say aye. Aye. Any opposed?
Consent?
Senator Whitley moves consent, seconded by Senator Chanley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, Senator Gannon.
Sure.
Okay. Okay, next we have House Bill 470. I'd like to move ITL, seconded by Senator Gannon. We passed something very similar to this last year. It went into effect. It hasn't even been in effect for a year. I'd like to give that a little more time before we start expanding what we're going to say no to. So that's the reason for the ITO. Senator Whitney.
Thank you, Madam Chair. And I am very grateful of what we passed last year. I just, we heard from DHHS saying that they just need to be able to respond quickly to the variety of drugs that may hit the supply or may hit the street at a certain time. And so I felt like this was a good way to give folks that flexibility. And, I think it's undeniable that this is an evidence-based strategy to save lives. And I'm disappointed we can't pass this.
Are there any further comments?
I'll comment.
Senator Gannon.
The police opposed it. Drug paraphernalia definition was too broad, so it's going to handicap drug enforcement. The trace amounts left give the police probable cause often. They were going to allow that. The 10 milligram to me was basically legalizing the drug. So didn't like that. And users are still going to want a bigger high. They're still going to use the tainted drug. I don't see them backing off. We had testimony from the police that said they would still use the tainted drug. So no.
Senator Chanley.
Thank you, Madam Chair. In some ways, I am a little on the fence on this because I thought that I could pass this. I think that it allows us to, we heard, based on the testimony from the advocates in the advocates for drug safety and harm reduction and the Department of Health and Human Services, I could pass it. But I think in much the same way we thought about the last bill, I'd really be, I may have also been open to interim study, but I think ITLing suggests that there's no value, and it's perhaps an ITL and an interim study don't work that differently, but I would have been more comfortable with an ITL perhaps, but in any case, interim study, I'm sorry.
Okay. Okay. Are there any further comments or questions? Okay. Seeing none, all in favor say aye. Aye.
Aye.
Opposed?
No.
Okay, so 3-2. Senator Gannon, you want to do this one again? Okay. Okay. Next we have House Bill 593. I'd like to make the underlying motion of ought to pass. And we have an amendment that would like to bring forward to the committee which is amendment number 1370S. And I'd like to move ought to pass on the amendment. No, we're doing the amendment.
Okay.
Do you need a second on the underlying bill? I'll second the underlying. I'll second the amendment.
Okay. The amendment is very simple. It removes the senators. It just removes the senators. This is an issue that the House keeps bringing forward at this point. In discussion, we have looked at this for so long. So if the House members would like to have a study committee, we will say, okay, you can have it, but we're done. Senator Adams.
I just will say, and I'm going to support the amendment, but as a member of the House last term, they once insisted on amending a bill to, instead of it being 2 House members and 1 senator, that they flipped it and made 2 senators, 1 House member. I forget whatever happened to that bill, but when they see this, who knows what they're going to do.
So, the only thing because we took the senators, I just looked and said, okay, 2 members. Should we have a committee amendment to make it 3 members of the House? So that way it's not even.
I'll second that amendment.
So are you folks, Matthew, will get a committee amendment having it be 3 members of the House as opposed to 2, because we never like the even numbers. So, okay, so we have a proposed committee amendment that on line 4 of amendment number 1370S changes it from 2 members of the House of Representatives to 3. Okay, so that's a proposed amendment. All in favor say aye.
Aye.
Aye. Any opposed? Okay. So we have the motion of ought to pass. I'll move ought to pass as amended.
Second.
Seconded by Senator Whitley. Is there any discussion on the ought to pass as amended motion? Okay. Seeing none. All in favor say aye.
Aye.
Aye. Any opposed? Okay, so it's 5 to,
Move consent.
Senator Whitley moves consent. Is there a second? Seconded by Senator Gannon. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, and I'll do this one. Okay. Next, we have House Bill 1002, and I would like to move ought to pass.
I'll second.
Okay. I don't believe that there are any amendments to this, so I don't know why I had ought to pass as amended here. Is there any discussion on the bill? Senator Chandler, then Senator Whitley.
Thank you, Madam Chair. I was just going to say this bill, as we have it before us, is a result of lots of work from lots of stakeholders, lots of compromise, and it seems very workable and the best solution that we can arrive at.
Yes. Oh, this one.
That
Is this is
1220.
full?
We have an
No,
amendment.
this is it. It's like a floor amendment. I don't think that. Okay, let's see.
I don't have in my notes that we have an amendment.
No, I think.
Yeah, I don't know why. I think it was because I had all these amendments.
Because it has been amended.
It has been amended.
But not by
Because
us.
maybe that is that. And I think that for me, one of the things that was, one part of this that was really powerful was the testimony from Ms. Ortolano from Nashua. And how she talked about the costs because they kept charging her for every email and every response and the attachments. And I think that in the bill we received from the House on page 2, lines 12 through 15, for the purposes of this paragraph, attachments to electronic communication shall be considered part of a single communication. So no longer can they charge her for everything. If there's one email all the responses to that email, as well as any attachments, only count as one, and that an individual can file 250 requests in a month, every month. So I think this was a very good compromise between all parties. I know there were some folks who weren't happy with it, but I do believe that it's going to provide some direction, and I think it's going to support individuals that that really use the 91A. And I think it just clarifies a lot of things, and it is much better than what originally passed the House. So, okay, so we have a motion of ought to pass. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for consent?
Second.
Moved by Senator Chanley, seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Who would like to take this one up? Okay, Senator Chanley. Okay. Okay, next we have 1038. I'd like to move ought to pass. I would like to congratulate the prime sponsor of the bill. Third time's the charm. I think he really listened to the concerns, and I had some Senate research done last year when he filed the bill, and after when it failed, I gave him the research, and I can tell that he actually looked at it, he read it, he's very serious about this, and I think this is in a good place. So I just want to thank him for doing that work. So we have a motion of ought to pass. Is there any further discussion on the ought to pass motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay. Is there a consent calendar motion?
So moved.
Moved by Senator Whitley, seconded by Senator Chanley. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye. Aye. Any opposed? Okay. And I will do this one, Matthew. Okay. Next, we have House Bill 1111.
ITL.
Okay, we have an ITL motion, and there's a second. Okay, is there a discussion?
I just, there was broad consensus from a lot of parties that, there were just a lot of concerns with this bill. I really don't want to do anything that would jeopardize the safety of children, and I feel like this is not getting there. So I think this is the right motion.
Okay. Any further discussion? Senator, I mean, you and I both do a lot of work on kids, and what I'm concerned about is the very chilling effect this could have on people reporting. But then again, you see the other point, that there are people who make fictitious reports, and I don't think this bill gets to that. And so hopefully the sponsor of this will continue to work on it and maybe work with the advocates and come up with something that that's really a compromise between the two. Okay, are there any further discussions? We have an ITL motion. Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay.
Consent?
So we have the consent calendar motion. Is there a second?
Second.
Seconded by Senator Chanley. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye. Aye. Any opposed?
I'm happy to take it out.
Okay, Senator Whitley wants to take it out. Okay. Next we have House Bill 1186. I'd like to move ought to pass. And as for an underlying motion, and I'm going to ask Mr. Hale to come forward because I would like to propose amendment number 1285S. And so is there a second? Seconded by Senator Gannon. So this one had to deal with firearms and codes. If you want to walk us through that.
Sure. Madam Chair, honorable members of the Senate Judiciary Committee, for the record, my name is Ryan Hale, Vice President of Government Relations for New Hampshire Bankers. In our testimony at the public hearing, we the amendment that we propose, that actually the language we asked for, just make some additional clarifying changes to it. First, the first change is the definition of firearms code. As it came over from the House, it was very specific to a category code that was issued on September 2022. The change being made in the amended language in front of you is more broad. It just it says a merchant category code established by the International Organizations for Standardization for Firearms Retailers. The reason for that change is if that code ever changes, you don't have to come back and make a legislative change. The other change being made is simply adding the definition, adding payment card acquirer. They're the ones that actually issue these codes. So adding that was important. And the whole purpose for us is banks don't issue these codes. We needed additional clarifying language to ensure that we're not swept into it. And this is language that industry-wide has been working on, banks around the country, as well as the credit card processors through our national organizations. So,
Okay, thank you very
I'm
much.
happy to take any questions.
Okay, thank you. Does Senator Chandler?
And perhaps it might not be the right question for you, so just that. One of the groups we didn't hear from that I recall were firearms merchants. Do you know if they had a position regarding the ban as opposed to a choice?
I'm not aware. Yeah, I'm sorry. Not aware of a position.
That's fine.
I'm looking, I don't believe anyone from the gun manufacturers, but I believe the issue was addressed. Okay. Okay. So we have this amendment, which is amendment number 1285S. Is there any further discussion on the amendment? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, I'd like to move ought to pass as amended on House Bill 1186. Is there a second? Second by Senator Gannon. Is there any discussion on the bill as amended? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay. Senator Abbas, would you like to take this one out? Okay.
I'd also just like thank you, Senator Carson, for bringing the amendment in.
You're welcome. Okay, next we have House Bill 1237. I'd like to move ITL. Seconded by Senator Gannon. I'm just going to leave it there. Okay. Do you have a comment, Senator? 1237.
The comment would be that the unmarked cars are used by administrators, not primarily by patrol.
Yeah.
Yeah, I don't see any reason to allow this. If someone is if a police officer is trying to stop someone in an unmarked car, and that person calls the police or 911 to verify the person trying to stop the police officer, they're not going to get in trouble for resisting arrest. I've never heard of that happen in any state ever.
Yeah.
That the person was still charged with like resisting arrest or failure to stop or whatnot. So this is just I understand the theories of this, but it doesn't really accomplish any, my humble opinion.
Well, if you think about it, and women are told if you're driving alone at night and all of a sudden there's a car behind you with a blue light, just keep going. Drive to the police station, and you're not going to get in trouble. So this is kind of the same thing. So we have an ITL motion. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay.
Consent.
Okay, Senator Whitley moves consent, seconded by Senator Chamley. Is there any further discussion on the ITL motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? No? Okay. Who would like to do this one? Anybody want? Senator Abbas, okay. 1237. Next we have, House Bill, 1260. I'd like to move on to pass. Okay, seconded by Senator Chandley. I thought this was a good bill, and it's gonna close the loophole that currently exists in our law. So, okay, so we have an ought to pass motion. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay. Senator Whitley moves consent, seconded by Senator Chandley. Is there any further discussion on the ought to pass motion? Okay. For consent? Oh, we are, I'm sorry, I misspoke. We're on the consent motion. Sorry, I didn't want to get everyone confused. So all in favor of the consent calendar motion, say aye. Aye. Any opposed? Okay. Who would like to take this one? Senator Chandley? Okay. Okay. I think we're going to hold 1263. But no? We said we were going to do that. Pardon? Oh, I changed my mind? But that's okay. Okay, we have House Bill 1263.
Are we doing it? We are doing it.
Yes, we're going to.
Do you want me to make the motion?
Yeah, if you'd like.
Interim study.
Okay, so we have a motion of interim study,
I'll second.
seconded by Senator Chandley. Is there any discussion?
I will just say, again, there are many folks that opposed it. I think it was noted in the fiscal note, it would really jeopardize the solvency of the mediation and arbitration fund. I don't think we want to do that. And it does, so I'll just stop there.
Okay. So we have the interim study motion. Is there any further discussion on the interim study motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay.
Consent.
Senator Whitley moves consent, seconded by Senator Shanley. Okay, is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, Senator Whitley, do you want to?
Sure.
Okay. Okay, next we have House Bill 1266. I'd like to move interim study.
Second.
Seconded by Senator Whitley. We've seen this before, and there's just a lot of concern that if you have people videotaping here, we heard that they're going to use it for themselves, but there's questions of accuracy. We know people can manipulate these tapes and recordings, put them out on social media. There's nothing to stop them from happening. So we just think it probably needs some more work before it's ready to come forward. Yes, Senator, I'm sorry.
Thank you, Madam Chair.
It's been a long day.
Yeah, seriously.
The courts also often permit this, but if you put this in RSA, it's kind of makes it a strict, tight policy where the court kind of adjusts to the circumstances in front of them on that particular situation, shall we say. So the court it's not like no one's being allowed to do this per se, but I think taking the flexibility away from the court's not a good idea.
Yeah, I would agree on that. And there's one thing that was said by Representative Katab. She framed the bill as a crucial step towards ensuring transparency and accuracy in family court proceedings. Keep that in your mind because we're going to talk a little bit about that on another bill. So we have the motion of interim study. Is there any further discussion of interim study? Okay, seeing none, all in favor say aye. Aye. Any opposed?
Consent.
Okay, Senator Whitley moves consent, seconded by Senator Chandley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Senator Abbott, you want to do this one?
Sure.
Okay. Okay. Next, we have House Bill 1340 relative to the exclusion of incarceration as voluntary unemployment for purposes of calculation of child support. I move to pass. Is there a second by Senator Whitley? No one opposed the bill. It makes complete sense. There is a court case, New Hampshire versus Corey Lounder, that was discussed, and so even the Bureau of Child Support Services supported the bill.
Yeah, and I will say, Madam Chair, if I could, I was compelled by the fact that the Bureau thought that they really needed this to actually fully comply with existing federal regs.
Correct.
Yeah.
Okay, so is there any further discussion on the ought to pass motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
Consent?
Okay. So Senator Whitley moves consent calendar, seconded by Senator Chandley. Is there any further discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Senator Whitley, you want to take this one out? Okay. Next we have House Bill 1412. I'd like to move ITL. Okay, seconded by Senator Chandley. Remember what I told you to remember? Why would we do this? There's concern that these transcripts that are being created are not being done properly, and that we actually hire that service out. So why would we take away the licensure and regulation of court reporters, which we had testimony that lawyers will sometimes hire on their own to sit in the courtroom? It just doesn't make any sense. So that's Senator Abbas.
Again, there's the paper, what says on paper and what happens in the real world. Whenever I get an audio, I don't always listen to it. I just send it right to the reporter to type it up. So I would hope that person because they have training and whatnot, they have a certification that they represent the pains and penalty of perjury, that, this is accurate based on the audio. Now, this doesn't even have a required person has a perjury conviction, which I wouldn't even know. I don't do a background check on these folks because they have the certification. And to get the certification, it didn't seem like it was a real tall order to get into it. It wasn't, it's not that difficult. So I think I'm not really getting rid of this at this time at least.
Okay. So we have a motion of ITL. Is there any further discussion? Seeing none, all in favor say aye. Aye. Any opposed? Okay, is there a consent calendar motion? Moved by Senator Whitley, seconded by Senator Chandley. It's kind of looking at Senator Avard on the Senate floor when you want a second for a roll call.
But he's usually the first.
I know he is. So, okay, so we have a consent calendar motion. Is there any further discussion? Seeing none, all in favor say aye. Aye. Any opposed? Okay. Who would like to take this one out? Okay, Gannon, okay. And our last one for the day is House Bill 1639. I'd like to move on to pass. Seconded by Senator Gannon. Is there any discussion on the ought to pass motion? Because basically this just cleans up existing language.
That's fair.
That needs to be done. So is there any further discussion on the ought to pass motion? Okay. Seeing none, all in favor say aye. 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 Any opposed? Okay. Is there a consent calendar motion?
And
Okay.
second.
Okay. Moved and seconded. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye. Aye. Any opposed? Okay. Who would like to do this one? Senator Whitley, you want to do this one? Okay. Okay. Seeing that that is the last bill we're going to do today, can I get a motion to come out of consent, out of executive? Moved by Senator Gannon, seconded by Senator Chandler. All in favor say aye. Aye. Any opposed? Thank you. Okay, just to remind everybody, we're meeting 3 days next week. We're meeting Tuesday. Yeah, no, it's more than time. No, it's double time. No. We're meeting Tuesday. I believe we're hearing 7 bills that day. We're meeting Wednesday. We're going to hear 1 bill and hopefully we'll be able to exec some more. And then we're going to be here all day Thursday. I know. We've got to get. We can wear it again next week. All right. We are done our business for the day. Thank you all very much. Take care.